So, good morning, everybody. We are being webcast today, so keep in mind that the public will be looking at what we're doing, or might be looking at what we're doing. So I wore my tie today to do that. My name is James Efting. I'm an attorney. I've been licensed almost 40 years. I went to University of Santa Clara when it was University of Santa Clara. Now it's Santa Clara University. I'm never quite sure why. We have microphones today so that people could hear a little better. You'll see there's kind of a thing called push right in the front of the microphone. You push on that and the green light will go on. And then when you're done, if you push again, have the green light go off. That makes sure people can hear you or not hear you, however you want that to be. So, again, my name is James Efting. We have Mark Torres-Gill here, who is in charge.
Assistant Director.
Assistant Director. And then we have Amy over here, who is, you're the director then?
Yes.
Okay, so I'm surrounded by director and assistant
My
director.
boss.
Okay. Next to Mark is David. Do you want to introduce yourself a little bit, David?
Sure. I am the relatively new counsel in the Moral Character Division of Admissions. I've been an attorney since 2006. I did capital habeas work for a number of years. Oh, thank you, Mark. And after I did capital habeas work, I worked at the Commission on Judicial Performance for a number of years, reviewing and investigating judicial complaints. And then I worked as an investigator in the Office of Chief Trial Counsel here at the State Bar. And as of 2 weeks ago, I'm now in admissions. Nice to see everybody.
Ezra?
Good morning, I'm Ezra Angeles. Sorry.
It's hard to remember.
Good morning, I'm Ezra Angeles. I'm the committee coordinator. I provide administrative support for the meetings.
So anything you want done, ask Ezra. She'll make sure it gets done for you. So that's where we go to. Tara?
Good morning. My name is Tara Clark. I'm the program manager for Moral Character.
My name is Michael Glass. I'm a supervising attorney with the Office of Chief Trial Counsel for the State Bar in the Los Angeles office, and I've been with them for 18 years.
Hi, I'm Desti Overpeck. I'm an attorney in the Office of General Counsel.
And we'll kind of explain why these people are important as we get a little farther on the road. Larry?
My name's Larry Kaplan. I am a public member of the Committee of Bar Examiners appointed by the Speaker of the California Assembly, and I'm delighted to be serving on this working group.
Okay. Do we have the judge on yet? I didn't hear her. Okay, well, when our other member of the committee joins, we'll introduce our judge to us. So, Patrick, you want to start with you next?
Sure. Okay. I'm Patrick Piggott. I've been an attorney 50 years, and I'm Dean of Dravon School of Law, Humphreys University in Stockton. I was once Assistant Counsel, Secretary of the Navy, Washington, D.C. I've been a DA. I've been Assistant Attorney General of America and Samoa. Been in long years of private practice, so I have a little experience.
Thank you. Meredith?
I'm Meredith D'Angelo, Assistant Dean for Student Affairs at the University of San Diego School of Law. I'm an voluntarily inactive member of the State Bar, and I've been in legal education for about 15 years, the last 5 of which in the Dean of Students role.
Debbie?
Hi, I'm Debbie Mukamal. I'm the Executive Director of the Stanford Criminal Justice Center. I'm actually licensed to practice in New York, but I think my role here is that we've just completed a study on the barriers to admission to law school and to the State Bar for people with criminal records.
Okay, good to have you with you. And Michael?
Is it the top button?
It's the bottom toward the front. It says push. Hard to read, but it's there.
In the middle. Sorry. Oh, I see. Okay. Yes, Michael Clancy. I'm from Sacramento, California, from Northwestern California University, the dean of the school. I've been in practice for 45 years, I guess it is now, in California. Been licensed for 11 years in England and Wales as well as a lawyer. And was in practice, in a civilian practice, doing criminal and civil work for a firm in Sacramento. Also have time having served as a judge advocate in the Marine Corps.
Thank you. As I said, we've got one more committee member who will join us and we'll explain who she is later. So Mark's going to give you some opening remarks, but I want to say thank you for coming here today. I think this is a bigger task than at least I understood when I signed up for it, and I appreciate you guys coming here today. I think it's very important. I care about the students that we're getting down the road who are going to be taking over as we kind of lead the practice. So hopefully we can do a good job for the State Bar and our students. Oh, I'm sorry. Knew it this first time being here. So to start our committee, our meeting, we're required, or we should call for public comment to see if there's anybody from the public who would like to make a comment before we start the meeting. Is there anybody from the public on the phone who would like to make a comment? I don't see anybody or hear anybody. So Mark, you want to take over from here?
Yes. Again, I want to reiterate what Jim said, which is thank you. Thank you to all of you for volunteering to work with us in what we believe to be a very important task of reviewing moral character standards and guidelines, that we have today, and hopefully in the end, come up with a product that is transparent and consistent and also informative, not only to staff and to the committee, but as importantly to the applicants who rely on our system and have to undergo this particular process. What we're going to do today, this is our first meeting, and I thought that it would be best if what we did first was to give you an overview of the landscape of moral character. What we do, how we do it, the statutes that apply, perhaps a discussion of some of the cases the more Supreme Court cases that have come down, that have applied, that have discussed moral character, and our process. Now, I know that some of you are more familiar with our process than perhaps others. I know Larry and certainly Judge Torrealba and Jim here are fairly familiar, having worked on the subcommittee of moral character for the CBE and having been involved in discussions about what we do in this area and how we do it, and then being involved in our informal conferences. So, but nevertheless, I thought so we're going to start with 4 different presentations, each covering different areas that we think may be helpful to all of you in the long run. I want to also emphasize that we have staff here. We are at your service. We're here to help you. We're here to provide you additional information. The information you're going to receive today is an overview. It's not exhaustive of what we do or how we do it. But as you move forward in this process, you may have additional information that you need, additional documentation or additional explanation, and we are here to help you and to support you in your work. And we also have, as Michael introduced himself, he's an attorney with the Office of Chief Trial Counsel who does a lot of the moral character work for the Office of Chief Trial Counsel, and he defends us in appeals in the State Bar Court. When I say us, I mean the Committee of Bar Examiners. And so he's here as a resource as well. So, if you have questions about that aspect, and I know Michael can help as well. And Michael's about as familiar with the law of moral character, I think, as anyone. So he's here as well, and Desdi as well from the Office of Chief Trial Counsel. Before I begin with the first presentation, we have provided you all with binders. I believe I hope that you received those binders in advance and that you receive them, next week. And I hope those binders are helpful. The material in those binders, again, is not exhaustive. It's just binders intended to be supplemented later on, and with the other materials that you might want. And if I could sort of walk you through it real quickly, just to explain what it is, what this stuff is. Some of it's, of course, self-explanatory. The first tab, we prepared summary of most, if not all, we may have missed 1 or 2, but I think we captured most of them, of the Supreme Court cases that dealt with moral character, and briefed those cases, summarized them. so that you can get a sort of sense of what the Supreme Court does in these cases. In tab number two is a copy of the case of In re Glass. In re Glass was the most recent case to discuss moral character and the concept of rehabilitation by the Supreme Court, and that came down in 2014. That was the last time the Supreme Court, addressed the issue of moral character. And it's an important case, and we'll discuss that case in more detail later. The next tab 3 is the moral character statement. This is what appears on the State Bar's website, and it discusses moral character. It's not entitled Standards and Guidelines, but there's information here about moral character. Tab number 4, I believe this also appears on the State Bar's website, factors regarding moral character determination. So again, this is informational item that the public sees. Tab number 5 it's a list of the circumstances and aggravation and mitigation that we consider when evaluating moral character cases. I don't believe this is on the website, but I believe this is something that staff uses internally. But I believe that a number of these factors are discussed within the context of the statements that are written and are incorporated into the website. But we thought that we'd give this to you as well to make sure that you understand the full context of some of the factors that we apply. We also thought it would be helpful in tab number 6 to provide you with a list of the abeyance options to discuss what abeyances are, and then the kinds of options we apply in abeyances, and we can discuss more about how, what's an abeyance and how they come about. We can answer that question as we move forward. And then number 7 is a copy of our instructions for the moral character application, as well as a copy of the moral character application itself. This is both. This is, I believe, a copy of the application as it appears online on our new website, as well as in a hard copy. And then tab number 8, what we did was we surveyed a number of the other jurisdictions in the state of California, and pulled some samples of the standards and guidelines that are posted on other state websites. Not every state has what's called, moral character standards and guidelines on their websites. But what we thought is we provided here samples, a variety of some of the state standards and guidelines. We thought they might be helpful in your work as you move forward to see what other states have done in this area. Some are more informative than others, and so it's sort of, there's not one form for every state. And then tab number 9, this was a document that we presented, that we created, that is it's intended it's intended to give you a guide, or at least give you a roadmap of how you might want to perhaps approach this area in pieces, in some form of, in some sort of guided way. Of course, this is just a suggestion. The working group, of course, can move in different directions if it wants. But we thought that it might be helpful to provide at least a temporary form, or at least a suggested form, to help guide your discussions. And we're hoping that this particular form is helpful to you. I believe some additional documents were handed out.
Excuse me. I did turn this on.
Right, so additional documents are handed out today regarding mental health inquiries. I think at some point as you move forward in your discussions, probably not today, but maybe in a future meeting, you may want to have a discussion about mental health and how mental health sort of fits into our evaluations of the moral character of applicants, and how we approach it. And you may have questions, and you may have other suggestions on how we approach that particular and sensitive issue. So again, this binder is a living document. It's intended to, I think by the end of this process, it'll probably be twice as thick, if not thicker. but that's how we intended it. So, are there any questions about the binder? Okay. So why don't we move forward then with our first presentation? As we go through the presentations, feel free to ask questions, and we're trying to. We've only have I think until 2. I think we have a lunch today. And what time is the lunch break?
It's at our discretion, but we're planning to do it after the third presentation.
Okay. All right. So there will be a lunch break, and we want to make sure that we leave sufficient time for the working group to have a substantive discussion about how it wants to approach this process and the next steps. So why don't we begin then? I want to cover briefly sort of how we got here. What are we doing here? Why are we here? The process, this working group, and the concept of the working group began back in 2017, and it was sort of an outgrowth of the Governance in the Public Interest Task Force. And back in 2017, the Governance in the Public Interest Task Force recommended certain changes to the function and structure of the State Bar committees and commissions, including the Committee of Bar Examiners. And the whole idea was to examine sort of the relationship between the Board of Trustees and the committees and commissions in an effort to improve engagement and interaction and governance with respect to its committees. And with respect to the CBE, the Committee of Bar Examiners, consultants were hired to sort of study how the Committee of Bar Examiners conducted its business, including how the moral character process worked. In June of 2018, there were the consultants that were hired to examine the work of the Committee of Bar Examiners and its relationship to the Board of Trustees presented a draft report, and it's a fairly extensive report, and there were certain observations that the consultants made with respect to with respect to moral character and how we, and some of the processes that we have. They observed, one of the observations that was made was that the State Bar does not have published standards and guidelines. What we have is, we have the moral character statement, but we don't have anything that says these are our standards and guidelines in an articulated and clear basis. And the recommendation was that we develop more specific, clearly articulated standards and guidelines for moral character determinations. And as they noted here, the absence of standards and clear definitions regarding moral character is a problem shared by most other jurisdictions. Not all, but by most. And that it was important that we have some standards and guidelines, in order to promote transparency, promote consistency, so that it was recommended that we review the moral character policies and guidelines. That a final report was presented to the Board of Trustees in September 2018 that adopted many but not all of the recommendations of the consultants who prepared the draft report. And the recommendations that were made were that in fact a review of the moral character guidelines should be made. And again, it reiterated that that there was an absence of clear definitions regarding moral character. And those recommendations were in fact approved. Now, the concept of the working group, however, arose from a further study of the of law school engagement. This whole Governance in the Public Interest Task Force also had a section on our law school engagement and how we could develop more meaningful opportunities for participation with the law schools. And one of the ideas that stemmed from that discussion was the formation of working groups, ad hoc working groups. And one of the issues that we felt was ripe for discussion with the law schools and then aligned with issues that are confronted by the law school as well as the bar were issues with regard to moral character. You know, what is moral character? How do we apply it? I know those are issues that the law schools also face. And hence, we have representatives from accredited law schools, certified law schools, and registered law schools here on the working group. So that ad hoc working group came out of a discussion about how to further and improve law school engagement. So here we are. Now we have a moral character working group. The purpose of the working group, as has been articulated, is identified here. The Moral Character Working Group is tasked with evaluating the standards applied to moral character determinations. The purpose of this review and evaluation is to analyze our existing methodology and develop clear and appropriate guidelines for determining whether an applicant possesses the requisite moral character. The end product of this review will be to ensure greater uniformity and consistency in decision-making, provide transparency into the moral character evaluation process, and ensure the State Bar provides appropriate consideration for rehabilitative efforts undertaken by applicants. So that is the purpose of the working group, as articulated by staff as a result of the discussions that flowed from Appendix I and the governance of the Public Interest Task Force and the observations and recommendations of the consultants that we hired. So I hope that's somewhat illuminating. I know it was kind of a path to get you to this point. But we're excited about the work I think that's going to be done by the working group. And if you have any questions, Debbie?
Yeah, Mark, thank you so much. It's really helpful. Wondering if, as part of the purpose of the working group, would that include recommendations on what kind of data should be made available to the public?
I'm sorry, it's kind of
What kind of data should be made available to the public? Regarding decision-making?
If there's requests for data, or facts or statistics or numbers, let us know what those are. I think what we can do is sort of determine what's available and what's not available and what we can share.
Yeah, it's wonderful, like how helpful and the kind of information you want to provide the working group, but I'm wondering, as part of the recommendations that the working group makes back to the bar, is it appropriate, would it be appropriate as part of what the overall mission is to include recommendations regarding making data public in an effort to promote transparency?
Yeah, I think that probably
Okay,
would be.
I just wanted, I didn't know if you were
I mean-
mostly just about individual decision making, or it's also about sort of, what the trends are and, those kinds of things.
Yeah.
Well, I also want to just note that we also need to be careful with the data gathering process too, because some of this information is not public information. So I think, as we get to that point, we need to be very specific so we can really determine whether some of the data requests are appropriate or not.
Oh,
So
of course, yeah, I
as we
wouldn't
get
want to do anything that would be in violation, but
Oh, yeah.
just
Right.
in an effort towards building transparency.
What kind of data you're looking for? Like how many?
Like the number of applicants who apply every year who have, let's say, a criminal record, and then what the, what the outcome is of those decisions. Not individualistic, but aggregate data. So,
like of the 9,000 applicants we get 1 year, maybe 500 of them have some sort of criminal violation, and
Right.
and 60 of them or 20 of
right,
them end up.
that's all I want to
somewhere.
know, is like that kind of data.
Okay.
But I wasn't sure if that falls into the jurisdiction of this working group. That's what the question was really about.
No, I think it's an appropriate ask.
Okay.
Now, whether we have the data is another
Oh, yeah,
question.
yeah. I mean, I know.
But it's a completely appropriate ask.
Okay, that's all. Thank you.
Larry?
Are we also going to get into process? In other words, not necessarily things like guidelines and et cetera, but things like All I can do is give an example. For instance, some states will not let you begin the moral character application unless you pass the bar exam. We actually will let people begin the moral character process, even whether or not, that's the type of thing. Maybe decide, okay, we don't want it to be that way. We want to say you have to pass the bar before you even bother, that kind of thing.
Yeah, I think those are sort of more high-level discussions that, may not fit exactly within the scope of the purpose here. However, that doesn't mean that the moral character working group can't, as a sort of addendum to the work that you're doing here, say, these may be additional issues that, for in the future, should be considered. But there are larger policy issues, I think, that you're raising that may be a little bit outside the scope. But certainly, if those are issues that the working group thinks should be explored in the future, then certainly they should be noted and identified, in the final report to the Committee of Bar Examiners and the board.
On that same vein, I was looking through other states. Some of them say you can't apply until you've taken care of certain things. And I don't think we have that application now. So this group might say, we want to change the rules, so if you haven't completed your probation in a criminal matter, you can't even apply to be admitted. Or maybe we say, no, that's not relevant. I don't have an answer, but that's something we can do.
Mm-hmm.
I just want to add, I think, besides the general public, what is the kind of problem that we receive as deans, we don't really know what to tell the students is going to happen when they put in their morals check and they come back 2 years later. Oh, I had a misdemeanor marijuana conviction 12 years ago and they're asking for 10 years of income tax returns. So I don't know what to tell a student. What's the connection? And so I think at least the people that have to go through it need to be better informed.
Yeah, and I think, Patrick, that's exactly what the work that should be done here is to create the standards and guidelines that inform your students, future applicants on what they can expect in this process moving forward. And so that they're not surprised at the time they apply and that perhaps maybe take preventative steps in anticipation of questions that may be asked in connection with moral character. Hopefully the deliverable that you get on the end of this will be in fact, helpful in that regard, and I'm hoping that it will. But I think that's exactly that is completely aligned with with the work that I think you should be doing here. So and there may be lots of ways to do it. It may just be further explain. There may be further explanation. Maybe it's hypotheticals, within the context of the standards and guidelines. It's be creative. Let's see where we go with it. And you'll see in some of the other jurisdictions, I think they maybe do a better job, than us in sort of explaining, what their process is and sort of some of the standards that apply. I think that's sort of what we're reaching for here.
Well, and you mentioned involving the law schools. I think the deans and everybody in the law schools maybe need some addition to the guidelines that explain what is our role when they're students. Because now I keep getting calls. I'm an investigator from the bar. Did this student tell you they had a conviction? No. Isn't that awful? I said, well, no. I mean, am I supposed to be checked? Is there a requirement that I do that? Is there
Kelly Torialba has joined the conference.
Is there a requirement we should inform students? And it's not in our rules. Maybe there should be, because I think we should inform them.
Good morning, Judge. So,
Good morning. So sorry, I got delayed with court stuff.
No, how can you get delayed with court stuff?
So, Judge Jim Efting here. Do you want to kind of give you a short description of your involvement in the committee for the members here?
I'm new, so just that I'm a member of the State Bar Committee of Bar Examiners. Is there anything else for me to add?
And you're a judge in Los Angeles County.
I'm a judge in Los Angeles County, and I just finished calling a calendar, and I'm sitting in my courtroom here with you all now.
Okay. Thank you.
You're welcome.
So where next?
We're going to talk about the law of moral character. Sort of do a brief overview of what statutes and rules govern the work that we do in this area.
Sorry, Mark, can I make one quick comment? I just wanted to respond to something that Dean Piggott raised, and that is, and maybe this is the appropriate context for this conversation too, but I think, that what you highlighted is the role of the law school in relationship to moral character, reporting. Maybe that's not listed on here, but that would be a very nice, set of recommendations, or guidelines for us, as to, who carries out certain responsibilities, or what kind of accountability should exist within the school. Because we often see it too in the instances of transfers. This has been raised at like our registrar meeting. That is, what level of responsibilities, or if they're academic or disciplinary issues, how much information sharing should exist from one school to the next. And given that we oversee, registered in California and accredit some of these schools, I think it would be an appropriate topic to tackle with this group.
Well, I don't want to get too sidetracked here, but interesting. I had a gentleman apply to transfer from the University of Tennessee because he had been criminally charged with stalking a student, and they kicked him out of school. Now, if he didn't tell me that and applied to my school and I didn't know, would he tell the state bar, and do I have an obligation? That's the kind of issues that come up. I didn't know what to tell him. Because now we put it on our application, we ask him about criminals.
The next area we'd like to we're going to talk about is the law of moral character. It shouldn't take too long. I just want to go over some of the basic statutes and rules that we have and that apply to this area, just so that all of you are sort of informed of sort of the legal lay of the land here. And we begin with section 6001.1 of the Business and Professions Code. And this is sort of the guiding principle for all the work that the State Bar does, whether it's in admissions or OCTC or any other department of the State Bar. Our overriding and guiding principle is that protection of the public shall be the highest priority of the State Bar of California. That's the basis of our existence right there. Under Business and Professions Code section 6060B, it provides that to be certified for admission and a license to practice law, a person shall be of good moral character. That's in the B&P code, as well as, and that standard of a good moral character applies to out-of-state attorneys under the Business and Professions Code section 6062. It also applies to special admissions applicants, registered in-house counsel, registered legal services attorneys, registered foreign legal consultants, and the newest addition to the special admissions process is our registered military spouse attorneys. And that's those standards that they all must be of good moral character is outlined and described and codified in the California Rules of Court. So we also applicable in this area are the moral character admissions rules. Admissions rules in and of themselves are approved and adopted by the Committee of Bar Examiners and approved by the California Supreme Court. For moral character, those rules start at the admissions rules 4.40 at SEC. In 4.40A, it states that an applicant must be of good moral character as determined by the State Bar. The applicant has the burden of establishing that he or she is of good moral character. When I say revised rule pending, what I mean by that in this particular slide is that references to the committee have been replaced with references to the State Bar for the most part in the amended rules, and that those rules are now pending approval by the Supreme Court. An important part of the admissions rules is the definition of good moral character. And here we have it in Rule 4.40B, states good moral character includes but is not limited to qualities of honesty, fairness, candor, trustworthiness, observance of fiduciary responsibility, respect for and obedience to the law, and respect for the rights of others and the judicial process. The Supreme Court has endorsed the standard, and it's discussed in the case of In re Glass. Is it broad? Yes. Is it intentionally broad? I would say it probably is. And I think the intention here is, in the moral character context, to be able to give the Committee of Bar Examiners and staff sort of the ability to review a number of areas that may implicate an applicant's ability to practice and the protection of the public. Another source for legal guidance are the State Bar Court decisions and opinions. Those decisions and opinions that are rendered in the State Bar Court are confidential, and we cannot disclose them here, unfortunately, because they do provide us some substantial decisional guidance on how we approach the decisions that we make. And in fact, all of our moral character matters are highly confidential. You can imagine why. Because we look carefully at not just the application, but as many of you know, we look at financial records. We get criminal rap sheets. We look at DMV records. So there's a number of very highly sensitive and documents and materials that we look at and are considered when we review this area. When an applicant appeals from a decision of the State Bar Court, that appeal goes directly to the California Supreme Court. When those matters go to the California Supreme Court, they are at that time designated as public. Hence, we have Supreme Court decisions that we're able to disclose to you, in tab 1 of the binder. Thankfully, we have, at least the highest court's analysis of how this law should be applied, and so that is available to us and does provide us some public guidance and decisional law. I called a few of the sort of general legal principles, sort of broad legal principles that we see at times, not only in Supreme Court case law, but also in State Bar Court case law. I pulled those out to give you sort of a sense of how the court feels about this area. There's a quotation from In re Glass. Lawyers' good moral character is essential for the protection of clients and for the proper functioning of the judicial system. And here's one from In re Gossage. Persons of good moral character do not commit acts or crimes involving moral turpitude. And also, here's another quote from In re Glass. The fundamental question is whether the applicant is a fit and proper person to be admitted to practice law. The term good moral character embraces more than just the absence of acts involving moral turpitude. And I refer back to the definition of moral turpitude and admissions rules 4.40B that doesn't talk specifically about crimes involving moral turpitude. The universe of areas that we look at in this context is very wide, as expressed in the admissions rule and definition of good moral character. So it's much more than just crimes involving moral turpitude. I wanted to also sort of highlight some other principles or concepts that we encounter on a fairly frequent basis in this area when we're talking about rehabilitation, or we're talking about whether the person is in fact the same person they were when they committed misconduct and what they do as they're doing today. So there's three areas I thought we'd highlight, at least preliminarily. There are other areas. I wanted to talk just real briefly about remorse and insight. What does that mean? How do we apply it? Honesty and candor, which is an issue that comes up very frequently in this area. And then the last is the other principle I thought we'd sort of introduce today is the concept of rehabilitation, which we'll talk about in the next presentation. Remorse and insight, what is it? The court tells us it's a candid admission of wrongdoing, a full acknowledgement of the misconduct, and it's genuine remorse is considered a mitigating factor in moral character cases. It's not, however, by itself enough to establish rehabilitation. We'll explain that why later. And the court, as the court said, acknowledging wrongfulness of one's actions is an essential step towards rehabilitation, but it does not, in and of itself, establish rehabilitation. Also, In re Hall indicated that remorse is important, but it doesn't require what we call false penitence, which means that if a person truly believes that they're innocent of a crime or that they didn't commit misconduct, and that they have a sincere belief in that, and that it's a sincerely held and consistent belief that the misconduct that they've been alleged to have conducted, they did not actually do. Well, that sincerely held belief should be counted in their favor. It shouldn't be counted against them. If in fact there's we shouldn't be forcing people to falsely admit misconduct that they sincerely believe they did not do. And so, so within that context, and the Supreme Court has instructed us very clearly, remorse does not require false penitence. But overall, when it comes to insight and acknowledging wrongdoing, that is something that the committee looks at, very carefully, because it is an indicator of whether the individual has in fact absorbed the wrongfulness and understands and comprehends that that they may have done something that may not have been completely appropriate. Because I think that sort of introspection is, as we've been guided to understand, is an important step towards understanding that the person is no longer that same person that they were before. Honesty and candor comes up in an awful lot of different situations, but the court has said very clearly that honesty and candor is absolutely critical. As the court said here, honesty is absolutely fundamental to the practice of law. Without it, the profession is worse and valueless in the place it holds in the administration of justice. Honesty and candor, and Jim, can attest to this, and I believe Larry can too. And that it's an issue that comes up quite frequently in a number of different contexts. We have individual applicants who might be dishonest on third-party applications to other licensing agencies or to other state bars. They may have been, or maybe there's some discrepancy between what they're telling us and what they may have told somebody on a law school application. Or we do have instances when they're just intentionally not telling the truth, or there are omissions. And certainly when it comes to honesty, it's very important, although one has to also recognize that sort of immaterial or inadvertent omissions or inconsistent statements, that's not what we're talking about here. We're talking about being candid, being open, being thorough, and being accurate about what you're telling us. So that happens again. That happens. That issue comes up fairly frequently. I pulled this because this quotation from In re Gossage, because the court was specifically talking about candidness and honesty in the context of the moral character application itself. And the court in that case said, with respect to material omissions in moral character applications, whether it's caused by intentional concealment, reckless disregard for the truth, or an unreasonable refusal to perceive the need for disclosure, such an omission is itself strong evidence the applicant lacks the integrity or intellectual discernment required to be an attorney. That's not me talking, that's the Supreme Court talking. And so you can see sort of the weight that the court gives in connection with this particular principle and concept. That's a sort of a very quick sort of lay of the land in terms of the statutes that apply and the rules that apply. And if you have any questions now about any aspect of this, I'm happy to talk to you. Yes, Patrick?
Not a question, but a possible request.
Certainly.
These PowerPoints are not actually part of our book.
No, but they can be made.
Yeah, is it possible you can make them available to us, because it's really helpful. It's condensed a lot of stuff down. I tried to put together for myself, and I appreciate you've done it.
You bet, absolutely.
Yeah.
We'll make sure that's added.
He's got it already. This man's ahead of us.
Now we're going to talk about rehabilitation, and then it'll stop with the Mark Torres Gill Show, I promise. Rehabilitation is, a very important area. That's right. We can move on to the next PowerPoint. And in this particular PowerPoint, we're going to talk about in-rate glass a little bit, but first what I want to do is talk about how the Supreme Court sees rehabilitation and the test for rehabilitation as described by the California Supreme Court. I need my glasses. Okay. So let's begin with this concept, which is that in California, there is no act of misconduct that is an absolute bar to admission to the practice of law. And anyone who, it does not matter the misconduct or the crime, if the applicant has demonstrated sufficient rehabilitation, that person can be admitted, notwithstanding the seriousness of the misconduct. So we don't have, I believe there may be some jurisdictions that provide that, certain crimes are an absolute bar to admission. And I see Debbie shaking her head, so I know I'm right on that. But we do not. In fact, we have, there have been individuals with fairly serious crimes who have, gone through a period of introspection and have shown through a period of time that they are in fact rehabilitated. Now, applying this concept, is difficult. Judgments have to be made. What is rehabilitation? How is it applied? What does it mean? And what's sufficient? That's something that we struggle with here, and every day. And so it's the Supreme Court has said, with respect to rehabilitation, broadly speaking, that the court has to be convinced that the applicant is no longer the same person who behaved so poorly in the past. So how do we do that? Well, we'll get to that in just a minute. But again, as the court said here, or actually I think I said this, which is it must demonstrate a compelling showing of reform that will inspire public confidence that the applicant is fit to practice law. So the test has been enunciated by the California Supreme Court as follows. Where there have been serious acts of misconduct, an applicant must establish a compelling showing of rehabilitation and truly exemplary conduct over an extended period that would suffice to demonstrate his fitness for the practice of law. So we see that, and we break it down into its essential elements. The first is with respect to the seriousness of the misconduct. The courts have said the more serious the misconduct and the bad character evidence, the stronger the applicant's showing of rehabilitation must be. So we'll talk about in-rate glass a little bit, and where that was in fact there was some very serious misconduct in that case, and the court, applied a fairly strict test as to whether or not Mr. Glass was or was not sufficiently rehabilitated for admission. But the less, so it's sort of a sliding scale. If the misconduct is not quite serious, well then, a lesser standard applies. We don't need to apply a very strict test when evaluating the evidence of rehabilitation. Now, what does it mean to me with extended period of rehabilitation? What does that mean? A substantial period of exemplary conduct following the applicant's misdeeds. There's no set rule. It doesn't say, the court doesn't say, 1 year or 2 years or 3 years or 4 years or 5 years. There's a number of cases out there where there was serious misconduct and the exemplary conduct had to, the person had to be misconduct free for maybe 5 years, sometimes 3 years, sometimes 4 years. But I think a lot of it depends on what kind of things the applicant has been doing over the period of time that they have in fact been misconduct free. And the court has told us, that's given us other sort of guideposts. For example, when does the clock start ticking? Well, the clock, for example, if you're incarcerated, the court has said very clearly, look, if you're incarcerated, you may be behaving in prison, for example, but that doesn't start the clock ticking with respect to our evaluation of how long, you've been a good citizen. Because a person who is actually incarcerated or in prison and under governmental custodial care is supposed to behave. Okay, so that doesn't count. It starts after that. After you get out of prison where nobody's actually forcing you to behave, that's when the clock starts. There may be instances, and I think David here will discuss in Ray Glass, where that whole concept of, well, when did the period of rehabilitation, when did the clock start ticking? And it doesn't. If you're still committing even minor crimes during the period of time when you're supposed to behave, well, that may very well delay the time when the clock starts ticking and may impact that extended period of rehabilitation that's required, for this test. What does it mean to exemplary conduct? Well, the court has said, well, it's not only unblemished, but exemplary conduct. Well, what does that mean? Well, the court has said very clearly, well, it's much more than being a good citizen. We're all supposed to be good citizens. We're all supposed to obey the law. We're all supposed to pay our taxes. All of those things in this context don't count for the purpose of defining exemplary. Exemplary means much more than that. It means extending yourself and showing that you've made amends, showing that you are more than just a good citizen, because your burden is to show that you're not that same person and that you have in fact absorbed you consciously absorb the lesson to have been learned, and the demonstration of the lesson to have been learned is by doing something more and outside yourself to better the community or better your church or whatever it is. Again, it's not just about being a good citizen and behaving. It has to be more than that. And again, we'll talk more about that in just a while. So what we have, I want to, yes,
Can I
Debbie.
ask you one more question, or a question related to that? Does the exemplary conduct, is it related to the seriousness of the crime, so that the more serious the crime, the more community service, restitution, exemplary conduct the applicant needs to demonstrate?
Well, that, it's
in the same way that the seriousness of the crime has that relationship?
We don't necessarily apply it, that way. It's because I think it's sort of hard. That's a measurement that might be hard to make.
Yeah.
Right, and I get that, and so I think when it comes to serious misconduct, we're looking for some demonstrable and significant demonstrations of rehabilitation. There isn't an algorithm, for what that means or what it doesn't mean, but there has to be some evidence that there's more than just, complying with the law.
In practice though, like if it's a fairly old single conviction for something that's, let's say, fairly minor, does the person need to demonstrate less community service and restitution than someone who's been convicted of something more recently and more serious? I realize there's not an algorithm, but I'm just trying to understand what the standard is.
Yeah, we don't define the standard, that definitively. I think in this area, there's a lot of judgments that have to be made. And so, certainly if there's serious misconduct, we're going to be looking for, something more demonstrable. If it's less, and, I'm trying to figure out a better way to answer your question, and I don't think
I'll be a little more blunt. Like, we see the standard sometimes as being that someone needs to be Mother Teresa. And I'm wondering, like, what level of Mother Teresa one needs to be. Does it depend a little bit on the kind of conduct that they've been, what kind of moral character issues they have, right? So
Right. I mean, if there was money, if they were convicted of theft, right? Well, I think restitution in that context, might be an important.
Right. So there is a relationship between.
There should be some kind of relationship to the misconduct.
Okay, that's helpful.
Does that answer your question?
Yeah, that's super helpful. Yeah, it's just, it was really clear on number 1 and it wasn't as clear on number 3, and that's why I was asking for that clarification.
Okay.
Thanks.
So what I want to do now is turn the microphone over to David Lane. What we did was, we thought that there are 3 significant cases that were published by the Supreme Court that talk about rehabilitation and apply it. And I thought it might be helpful if we gave you some context for how it's applied in particular factual situations. And so I've asked David here to look at these 3 cases, Gossage, Mena, and Glass, and hopefully this discussion will give you sort of a sense of how it's applied in real life.
Thanks, Mark. And yeah, to your question, Debbie, I think it's safe to say that there is sort of a sliding scale there. And when the court says the more serious the misconduct and the bad character evidence, the stronger the applicant's showing of rehabilitation must be, given that rehabilitation includes exemplary conduct. Hopefully my discussion of these cases will sort of illustrate that for you. And I'm going to go in reverse chronological order. These are the 3 of the most recent cases where the court has applied the rehabilitation standard. And I'm going to start with Stephen Glass. Some of you may remember Stephen Glass wrote for the New Republic magazine in the 90s for a couple of years. He also did freelance work for others, Rolling Stone, Harper's, and some other publications. But he worked on staff for the New Republic between 1996 and 1998. And almost immediately upon his arrival there, he began to fabricate material for publication. He fabricated parts or entire articles. Ultimately, more than 40 articles during those 2 years were published either in the New Republic or other publications that were wholly or partly fabricated. And these fabrications were not innocuous in the sense that he targeted specific individuals. For example, he wrote an article about Vernon Jordan, Bill Clinton aide, that he purported to quote several unnamed sources, anonymous sources in Washington, D.C. who said disparaging things about Mr. Jordan. He also wrote articles that targeted specific political groups and ethnic minorities. He wrote articles that caricatured African Americans, people of Middle Eastern descent, things of that nature. So it was very serious misconduct. And also during that time, in 1997, during the 2 years he was fabricating these articles, he began law school at Georgetown. And in 1998, he was exposed, which is an interesting story in itself. I'm not going to get too much into the details, but suffice to say that Forbes magazine, somebody at Forbes read one of his articles, found it unbelievable, contacted his then editor, Charles Lane, at the New Republic, who quickly did an investigation and determined that Mr. Glass had been fabricating articles, and he was promptly fired from the New Republic. At that point, well, he graduated from Georgetown Law School in the year 2000 and decided to go to New York, and he passed the New York bar exam and submitted his application to the New York bar in 2002. Now, in that application, there were deficiencies. He exaggerated the cooperation that he purportedly gave to the publications that had published his articles. He claimed to have worked directly with the publications to identify the fabricated articles. His editor, Charles Lane, testified otherwise. He also failed to supply to the New York bar a complete list of the fabricated articles that had injured people. He named about 20 articles at the time in his application, and there were more than 40. Also, during the process where his application was being processed by the New York State Bar, he wrote a book, a novel version of what he had gone through. And he appeared on 60 Minutes shortly before it was published, and I'll get back to that in a minute. But in 2004, so this is 2 years after he applied, he was informally notified that his moral character application was not going to pass muster. That was the procedure in New York at the time. They would, I suppose, give applicants a chance to withdraw their application if they knew it wasn't going to get through, and he did just that in 2004. He withdrew his application and decided to move to California and try again. In 2006, he passed the California bar exam, and in 2007, he submitted his moral character application. And now, under scrutiny of the California bar, he was instructed as part of that process to really review all of his articles and identify fabrications. And during that process, he did identify fabrications that he previously had either denied affirmatively that they were fabricated during the New York bar process, or he had just failed to disclose altogether. And he additionally, during the California process, he wasn't forthright in acknowledging the defects in his New York application. The Committee of Bar Examiners decided to recommend to the California Supreme Court that Mr. Glass not be admitted. And Tara is going to discuss the procedures and the process in a little bit, but suffice to say for now, when the committee gives an adverse determination to an applicant, the applicant can then ask for an evidentiary hearing in the state bar court, and that's what Mr. Glass did. In 2010, the hearing department of the state bar court held a hearing, and Mr. Glass made the following arguments with respect to his rehabilitation. First, he said, as far as having failed to identify all of the fabricated articles and facts in the articles during the New York process, he said, well, I had hired counsel, and maybe I shouldn't have said I worked with the publications to identify the articles. I should have said I instructed my counsel to. He said that he had reviewed a list of articles from his counsel that the New Republic had provided to his counsel. It was later determined that that list was insufficient. It didn't contain 4 articles that had been fabricated. And when he reviewed that list, he had, again, affirmatively denied that 4 of the articles on the list were fabricated. It was later determined that they, in fact, were. He presented some impressive character witnesses, which the California Supreme Court has held carry significant weight but are not dispositive. He had a couple of Georgetown law professors testify in his behalf. He had a couple of judges for whom he had clerked after law school testify in his behalf. He had 2 psychiatrists testify who had treated him and testified that he had moved beyond his earlier misconduct. And he even had the owner of the New Republic, I believe still the owner of the New Republic, Martin Peretz, testify on his behalf. Now, his direct editor when he was working for the New Republic was Charles Lane. Mr. Peretz wasn't really involved in the day-to-day operations of the magazine, but he had become fond of Mr. Glass, and he testified on his behalf. And he had several friends and even some journalists testify that he, at that point, was an honest person, and he wouldn't do this again. He explained that the book he had written, the novel, he did not do that for his own benefit. He did that as a warning to young journalists so that they wouldn't make the same mistake he made. And he said that the 60 Minutes appearance that he made just before the publication of the book was not to publicize the book, rather that was so that he could issue a public apology for what he had done wrong. He also pointed out that after he had submitted his New York bar application, he had written about 100 letters of apology to journalists and other individuals who were affected or injured by his fabrications. And he also, since the time he left the New Republic, he had spoken at a journalism class and discussed his misconduct. He spoke at a high school class. He worked at a senior center for about a year, volunteered some of his time, and at the time he was going through the California moral character process, he was actually working as a law clerk in California, and he submitted that he was doing pro bono work in the sense that he was working on cases in which the firm did not expect to have fees paid by the clients. He explained the problems with his New York application by sort of shifting blame to his counsel, again saying, I hired counsel to deal with that. And he explained the fact that he failed to list all of the fabricated articles in his New York application by saying, well, I'd spoken to somebody at the New York bar on the phone, and they instructed me to list articles that involved real people like Vernon Jordan, who were injured, and those were the ones I was supposed to identify. So I didn't identify the articles that I wholly fabricated that just involved characters who didn't even exist. I didn't know I was supposed to disclose those. The hearing department of the State Bar Court was persuaded and disagreed with the committee's assessment and was going to recommend to the Supreme Court that he be admitted to practice law in California. The committee appealed that decision to the review department. The review department similarly was persuaded by Mr. Glass's arguments, and it too disagreed with the committee and recommended that he be admitted to practice law. The committee then took the matter to the California Supreme Court. The court ultimately agreed with the committee and did not admit him to practice law. And this is the rehabilitation analysis, going back to what Mark underlined, the standard of rehabilitation. First, they looked at the seriousness of the misconduct, and they noted it was rather obvious that it was very serious misconduct. It was conduct that involved moral turpitude, sustained over a period of 2 years. This wasn't just one incident. It was deceit, that he was motivated by professional ambition and personal gain. It was vicious and mean-spirited, and demonstrated a complete lack of compassion for others and an arrogance, not to mention prejudice against various ethnic groups. The court also noted the elaborate efforts Mr. Glass engaged in to cover up his fabrications. He fabricated reporter's notes. He made fake business cards of alleged sources. He had his brother pose as a source on the phone. This is all to fool the fact checkers at the New Republic, which, as an aside, I should say, when initially he was hired at the New Republic, he was the head fact checker. When Andrew Sullivan hired him at the New Republic. So the court, they noted he obviously had violated the ethical strictures of his own profession, the journalism profession. And Charles Lane, his direct editor, who ultimately had fired him from the New Republic, testified. And Mr. Lane actually testified that he had gone to the so-called Newseum in Washington, D.C., which is a museum about the news industry. And there was actually an exhibit at the time about Stephen Glass. And he was called there, the incident, it was called one of the worst episodes of deceit in journalistic history. The court additionally noted that a lot of it took place after he started law school at Georgetown. So this is when he was pursuing a law degree. The importance of honesty should have gained a new meaning for him at that point. And furthermore, his dishonesty, while he was exposed and fired in 1998, his dishonesty extended all the way up and through the California State Bar hearing, where he sort of shifted blame to his counsel. He didn't acknowledge the deficiencies in his New York application. And so, in short, the court said this is very serious misconduct. Therefore, he faced an elevated burden to get over to prove rehabilitation. The court then looked at the period of rehabilitation that followed the misconduct. Now, Mr. Glass had argued that he had been rehabilitated for 12 years, since 1998 up until 2010, when he had the hearing at the State Bar Court in California. But just as Mark mentioned, that when somebody is under the control and supervision of the criminal justice system, incarcerated on parole or probation, good behavior didn't carry much weight. Similarly, the court pointed out here that during much of those 12 years, he was under the scrutiny of the New York Bar or the California Bar. And so the court didn't give those years much weight, and ultimately determined that there had been about 5.5 years of a rehabilitative period where he wasn't being watched by anyone, and it was after the most egregious misconduct that he had committed. The court also noted that while the testimony of character witnesses is not sufficient to show rehabilitation, it is important, and particularly when attorneys testify on an applicant's behalf, the court gives that some weight. The court then moved on to sort of the third prong, if you will, of the rehabilitation analysis. Did Mr. Glass exhibit exemplary conduct during the rehabilitative period? The court noted that remorse alone does not establish rehabilitation. He seemed to be remorseful. They noted that while he had written those roughly 100 letters of apology, that was after he had applied to the New York Bar, or around the same time. And so the court did not give that much weight. And then the court pointed out that while he may have written the book as a warning to young journalists, he was also paid $175,000 advance, and the court didn't seem to buy his explanation of his 60 Minutes interview, which occurred just before publication of the book, that he was doing it to make a public apology. The court also noted that while he was allegedly doing pro bono work as a law clerk at that firm, he was being paid a salary of about $154,000 a year. So while for the firm that may have been pro bono work, and the firm wasn't going to receive fees, Mr. Glass certainly was, and that was in 2010. And this is, I think, important. The court, and now I'm quoting, the court said, quote, "We must recall that what is at stake is not compassion for Glass," unquote. And I think there's an important distinction there, that going back to Mark's initial point, the real focus here is public protection. It's not the applicant has a right to be an attorney. The issue is, how do we best protect the public? And in this case, the court ultimately, as I said, sided with the committee, reversed the underlying court's decisions, and Mr. Glass was not admitted. And currently, I believe he is still working as a law clerk and not as an attorney in California. The next case.
Let's see, how are we doing on time, by the way? Are we doing okay, Tara? Okay.
Yeah, these cases are fact heavy, but I'm gonna try to make this pretty quick. In re Eben Gossage. This opinion came down from the court in the year 2000. Eben Gossage he was from a prominent, politically well-connected family in San Francisco. Unfortunately, in the early 70s, 1972, he developed a severe heroin habit. And to support that habit, he engaged in theft, he forged checks, he stole checks from his family members, his mother, his grandmother. He ended up with a couple of convictions, felony forgery convictions, a little bit of jail time, he had probation. In 1975, Mr. Gossage was involved in an altercation with his sister, and he murdered his sister. He killed her in a brutal and violent manner. After that happened, he left the scene of the crime. He did not call for help. And then he later went by her apartment where he had killed her and asked the manager to let him in and feigned as though he couldn't reach her or something. And that's how it was discovered. Ultimately, he was tried and convicted of voluntary manslaughter, and he received a prison term of 2.5 years. That wasn't the end of his criminality. When he got out of prison, he was paroled. He picked up where he'd left off with his heroin habit. He had a couple of DUIs. He stole jewelry from family members. Public intoxication, you name it. And ultimately, he was, again, convicted for heroin-related crimes and public intoxication. He received a suspended prison term and 4 years probation. He later had a federal DUI. Why was it federal? He was on the Presidio in San Francisco. And at that time, his prior suspended term was no longer suspended, and he ended up actually going to federal prison. And when he got out of prison in the early 80s, 1983, that's when he finally got sober. And by all accounts, he actually remained sober from then on. And jumping forward a little, he went to law school in the late 80s. He passed the California bar exam in 1993. And in 94, he submitted his moral character application. That application contained incomplete and or incorrect answers about where he had lived and worked. He omitted many of his criminal convictions. And the committee decided to recommend that he not be admitted to practice law in California. As in Glass, Mr. Gossage asked for an evidentiary hearing in state bar court. The hearing department again disagreed with the committee, recommended that he be admitted. The committee again appealed to the review department, which again disagreed with the committee, affirmed the lower court's holding decision, and then the committee took it to the California Supreme Court. Now, his argument in state bar court for rehabilitation was, first, that since he had gotten sober since 1983, when he got out of prison, he had assisted nonprofit groups, he had lobbied local politicians in matters concerning pollution, things of that, environmental matters. He had volunteered on local political campaigns. He presented a number of character witnesses, including State Senator John Burton, the San Francisco District Attorney Terrence Hallinan, the San Francisco Public Defender at the time also, and a supervisor, Susan Bierman. He presented 5 attorney character witnesses, some of whom had represented him in his own matters, some were law school professors, others he knew. And he presented the testimony of 4 mental health professionals, one of whom actually testified that he may have antisocial personality disorder, which is sociopathy. The committee had a witness, a mental health professional, who said, and I want to get this phrase right, that there was possible residual inability or unwillingness to abide by societal rules. So the court then engaged in the rehabilitation analysis, the Supreme Court. First, the seriousness of the misconduct. The court pointed to the manslaughter conviction and said not only was it a manslaughter conviction, but there was moral turpitude involved in the sense that he didn't fess up to it, he hid the crime, he didn't call for help, etc. And the court also pointed to the financial crimes that he had engaged in, the forgeries and whatnot. The court then looked at how long his rehabilitative period was, and the review department in the State Bar Court had said, given him credit for 14 years, from sobriety in 1983 up until his State Bar Court hearing in 96. But again, the Supreme Court said, well, during much of that time, he was under the direct supervision of correctional authorities, either probation, parole, or in jail or prison. And he was also, during part of that time, under the scrutiny of the California Bar. So the court found, well, there might have been a rehabilitative period somewhere maybe less than 10 years from when he was discharged from probation until he submitted his moral character application. The court looked at whether he had displayed exemplary conduct during that period. And noted that actually during that entire roughly 10-year period, he had had multiple traffic violations, which standing alone might not have been a big deal, but he also mishandled the related proceedings. He failed to appear a number of times, things of that nature. The court also noted that he had submitted a deficient moral character application, and I think part of his explanation was, well, I didn't name all of my convictions and bad acts in the past because there were so many, it was hard to keep track. And the court didn't buy that. The court said, no, that's not how this works. You need to list everything. So just as in Glass, the court agreed with the committee and decided that he did not meet his burden of showing rehabilitation and he was not admitted to practice. To save a little time, I'm not going to get into the case of Joseph Mena, but I will just say, just as in Gossage and Glass, that was another case where the committee said no. Both parts of the State Bar Court said yes, and then the California Supreme Court again reversed the decision. And so those are really the three seminal and most recent cases in which the California Supreme Court applied the rehabilitation analysis and gave some guidance as to what it's looking for, albeit not bright lines, but at least guidance.
Excellent summary, thank you.
Mena is not in here. Right?
We noticed the omission. We'll be adding that and updating your Supreme Court case on this.
Yep, I appreciate it.
Just in a nutshell, what was his?
Sure. So in a nutshell, he had a gambling problem.
That's fine.
He had a gambling problem. He misappropriated $98,000 from his client trust account. He took loans from former clients. He defaulted on loans. It was a lot of money stuff, which the court doesn't take too kindly to. And he failed to pay it back. I think in all three of those cases, last thing I'll say, the State Bar Court seemed to have been impressed with the character witnesses, the quality of the witnesses, who they were, how many there were, and the fact that there were a lot of attorneys who testified on these folks' behalf.
Yeah, and in this area, when we have it's attorneys who present character references for applicants, those are given considerable weight, by the court, State Bar Court is, by the State Bar Court and the Supreme Court. So
I like the footnote that referenced that one of the letters came from a state senator, and that guy won. It's interesting.
Yep.
You mean
Sure,
the one
what's
who's election?
next on
No, the guy won a license to practice law.
I think we're at lunch now, Jim.
Okay. So is the plan to be a very short lunch, half an hour or less, or are we going to talk about your lunch?
Half an hour off the record.
Okay. So Judge, are you going to call back in half an hour?
Yes, I'll call back in a half an hour. Perfect. Thank you.
So we're off the record.
Kelly Torrialba.
Has left the conference.
Yeah.
So lunch is back in the corner there?
About these cases,
Yes.
because there's
Mr.
so
Sell?
you know,
No, it's okay. Just trying to stay on track, but absolutely.
If you'd like to join us by teleconference, please dial 844-755-3516. Again, that's 844-755-3516. And everyone has a moment, I'd like to poll for our next available meeting.
Right, so people can look at their calendars and see when the next available.
And then just let me know at the end of the meeting. So we're looking for in Los Angeles, the State Bar of California, July 2nd, July 25th, or July 26th.
Would it be the same hours,
Not necessarily, we can adjust them as needed.
or would it be daytime, morning, afternoon?
It'd be around this time frame, just depending on how much time we would need.
What were the dates again?
July 2nd, July 25th, or July 26th in Los Angeles.
Yeah, I'll be out of the country 25th and 26th.
What days, Patrick?
25th and 26th of July. My wife is Swedish and we always go to see her family every July. Except for I don't leave till the 15th.
Or if you guys just want to check your calendars at this time, and then just let me know at the end of the session.
And that would be at the bar office in Los Angeles.
Correct.
Okay, now next, we're going to ask Dusky to make a short presentation about how the rules apply to us.
Yeah, I just wanted to, or Jim actually suggested that I remind everyone that we are subject to the Bagley-Keene open meetings rules, which means that when we are not in a public meeting, please
Kelly
do not,
Torrialba.
Has joined the conference.
when we're not in a public meeting, please don't continue to discuss amongst yourselves any of the topics or discussions that we're having in this meeting, because the public is allowed to hear what people are thinking and their ideas. So if something comes up that you want to make sure gets shared, you can always send an email to one of the State Bar staff, and staff can send out an email to everybody. But please don't, email amongst yourselves, or if you're hanging out at some, meeting where you all happen to be there, please don't start talking about what we're doing in this group. We want to have all those conversations in the open meetings that are public.
If you have more questions, you can ask Dusty how that applies to us. Thank you, Dusty.
Yeah, thanks.
Okay, so Tara, are you going to take the next presentation?
Good afternoon again, everyone. So I'm going to talk about the guidelines and process of the moral character determination process as it stands. And some of this has already been discussed by Mark and David, but I'll just kind of briefly go over it again. So as Mark previously mentioned, as defined by Rule 4.40B, we have the moral character definition. I won't read it out loud, but it does include qualities of honesty, fairness, candor, and obedience to the law. And in your materials, tab 3, you have the moral character statement. This is the statement from our website. Again, these are just some of the highlights from it. I won't read the entire thing since you do have it in front of you. But as a reminder, so the applicant has the burden of establishing his or her good moral character, as well as, and Debbie, this may speak to your earlier question, while no misconduct precludes admission, persons who have been convicted of violent felonies involving moral turpitude, and crimes involving breach of fiduciary duty are presumed not to be of good moral character in the absence of pardon or showing of overwhelming reform and rehabilitation. Okay. And also in your materials tab 4, you have the factors regarding moral character. These again are currently posted to the website. So these are just some of the factors that we take into consideration during our evaluations of the applications. For example, again, in the second bullet point, it discusses truly exemplary conduct, and the more serious the misconduct, the stronger an applicant showing of rehabilitation must be. And as Mark mentioned earlier, so behaviors such as holding a steady job, abiding by the law, starting a family constitutes only normal behavior, so expected behavior, not exemplary conduct. And this list is included again in that printout in your materials. This is kind of just a truncated version for you, but factors that we do consider when reviewing the misconduct. So the age and education of the applicant at the time of the misconduct, any amends they've made, including restitution, expungement or receipt of a pardon, and in the event that someone has had a professional license suspended or revoked, reinstatement of that license. So this is not currently posted to the website, but it is something that we use as part of our evaluation. So this potentially could be something that would be incorporated in the new standard and guidelines depending on what you all recommend. But so factors we consider in aggravation are if the person was in a position of trust or confidence, if they've had numerous prior convictions with increasing seriousness, if they were already on probation while committing a new crime, as well as things like such as use of a weapon causing great bodily harm or threat. In addition, we also have the mitigating factors. So if the person was under a coercion or duress, if they had no apparent predisposition, it's unlikely to reoccur, and they have no record or prior record, or insignificant prior record. Okay. And so this is just a brief chart of how the process currently works. So we launched our new admissions information management system in March of this year. And so the applications are both electronic now, both the determination and the extension application. And we encourage applicants to apply in their third year of law school for the initial determination application, since the process can take a minimum of 6 months. The positive determination is valid for 3 years. And at the 30-month mark, so about 6 months before it expires, that's when applicants are eligible to file their extension application. And the extension application does not have to be fully processed before the expiration date. They just have to have applied again. So when an applicant...
Can you do that again for me?
Mm-hmm. Sorry. So the determination is valid for 3 years, so 36 months. At the 30-month mark, that's when an applicant may submit their extension application. So somewhere between the 30 and 36-month mark. However, the extension application does not have to be fully processed before the 36-month point. It's just that we have to have received it in order for us to continue processing and extend that positive determination.
Okay, so let's talk about why that would happen, because I think it's important for them to understand. Okay. So if an individual hasn't passed the bar exam yet, and they've applied for moral character, and they've been passed for moral character, they may be continuing taking the bar, and they say, hey, I need 2 more chances at the bar, so that's when they would want an extension.
Correct. So
it's the extension to do everything else needed to get the license.
Correct.
Okay.
Thanks, Jim.
Can I ask a question?
Mm-hmm.
Has there been a change in the staff person who does this pre-processing because your change is in March? Who does it now?
No, so we still have the same essential staff. All it is rather than, because initially the process, prior to March, the process was that they would complete the application online. They would print out a copy and mail that to Los Angeles. Now they complete it online. They mail in just any supplemental material that's required, so certificate of good standing, the FD-258 fingerprint cards. But so pre-processing will still go through those initial electronic applications to ensure that the questions were answered correctly, the supplemental documents were provided, such as driving records from out of state. So it's still the same staff in Los Angeles who's doing it.
Okay. And do they have a time frame for when they need to reply if there's more they need, or it's suddenly taking so long?
It has been a bit of an adjustment, I think, with the new system. We're also dealing with, we have applications that were submitted initially on the old system and now have migrated over, and so we're kind of working in both the hard copy application as well as the new system. So Ideally, we try to review them as quickly as possible to try to let the applicants know if there's any deficiencies, but it can take a little while. I think we're working at about the 90-day mark currently. We try to get it down to at least the 60-day mark, if not sooner, so.
So about 90 now, but the goal is 60.
I think your question was, if the committee says we need more information, how long do they have to
Well,
provide the
not the
information?
committee, just this pre-processing individual who reviews it.
The assigned process person
Yeah.
would say, hey, I need to see your driving record.
Yeah.
They have, what, 60 or 90 days to provide that?
So once pre-processing then lets an applicant know of a deficiency, they have 60 days to provide it, so.
And, oh, I'm sorry, go ahead.
Well, I thought that topic was over. I was going to ask about the extension. How long is it? In other words, if somebody received a positive determination and they're trying to satisfy the other requirements, how long are they going to get out of this extension?
So it's another 3 years.
3 years. Okay.
And what I wanted to mention was that, overall, this process that we undertake is sort of is normally going to take some time because we're looking at a number of different things, and it's not just the application that we're looking at. And as I mentioned before, there's a process. They have to be fingerprinted, and so we're going to get the criminal offender history. That takes some time. We're going to get they have to submit the DMV records. We've got to get the certificates of good standing. There's other documentation from third parties that don't always arrive quickly or promptly. We start, but typically, I'd say maybe 40–50% of the individuals who come through our system are cleared fairly rapidly within 90 days. Tara?
So we do have a chunk of applications that are cleared by the pre-processing unit, so they either have no notable or very minimal information or misconduct, something of that nature, and then the remaining applications come up to San Francisco to an investigator, to the actual moral character unit.
Yeah.
So fingerprints aren't required before they submit the application?
They're required at the time on or close to the time they submit their application.
So you should have it all when you get the first application.
So the way that it's working now with the new system is that as soon as an applicant submits the application online, they'll receive an email that contains the live scan form. The live scan form now has their file number as well as their case number, so it's a little more customized to them directly. If it is somebody that submitted it with the hard copy fingerprint cards, then they just have the 60 days to submit those to us.
Thank you.
Okay. There are two kind of lines that run parallel with each other, kind of cross. You have your moral determination, and then you've got a certain period of time when you have to pass the bar. But then on the other hand, you could pass the bar, then you have 5 years to get your moral character. And we get people who pass the bar but don't get their moral character in time, and therefore lose their passing the bar because they haven't got moral character correct or passed, or vice versa, they've got moral character but they haven't passed the bar. So it's important to kind of keep both those lines in mind.
There's really some people that can't get it done in 5 years?
Oddly enough, yes, we
Yeah.
probably get 1 or 2 a year who we have to talk to about that.
Unusual, yeah.
Yeah, and again, it's a part of the score, moral character, moral exam, 2 separate tracks. Okay.
Okay.
So once the application has been submitted to pre-processing, if it's determined that any further review or investigation is needed, it is referred again to an investigator in San Francisco, so that's our moral character unit itself. If staff cannot clear the application, then that's when currently it's referred to the committee for an informal conference. The informal conferences are held in San Francisco and Los Angeles, and they consist of either between 2 to 4 committee of bar examiners members, the applicant, staff, and if the applicant has counsel. After the informal conference, the subcommittee will make a recommendation to the full committee at their next meeting, and then the applicant would receive the determination after that.
Tara, could you maybe give a little more information of how the informal conferences work and sort of maybe a little more context on who goes to, who we invite to informal conferences?
Yeah, and who makes that determination to send it to a conference?
Right, so we actually have another slide in a moment, so if I could
never
do that
mind
next.
that.
But, because I'm just kind of overview
We're
right now.
getting to the meat of it now.
We're getting the meat.
Yeah.
And that's gonna change. You're gonna talk about how that's changing now too.
Yes,
right?
that's the next thing. So, I'm getting there. All right, so that's the current as it is. That's the current process as it is. As Mark mentioned, the admissions rules have been changed and approved by the Board of Trustees. However, we are still waiting for approval by the California Supreme Court. So once that those roles are changed. Staff will actually take over informal conferences. And so what will happen is staff will hold the informal conference. We will make an initial determination. However, the applicant will have the ability to have an appeal to the Committee of Bar Examiners. So there will be an intermediary step, between before a state bar court. So now they'll have another appellate body to be able to review it.
I know I'm asking lots of questions, sorry. You say staff, who does that mean? It means non-attorney staff, it means staff that have been working here for a while, does it mean you're hiring new people?
So
Who's the
staff within the moral character unit or the Office of Admissions as needed. So currently it would be myself, David, I believe the supervisors will also be designated. In the event that we need it, Mark may also be a person on the panel. So it would kind of depend on the availability, but the idea, I believe, correct me if I'm wrong, is to have a consistent group of people hosting these conferences to try to create a little bit more consistency. Each case is evaluated on a case-by-case basis, but just to have that knowledge within the core group of people.
But those people will have an attorney who can help them.
Yes, and so David is the attorney. This is the reason why he was hired for the unit, so he will be present, or an attorney will be present.
Yeah, there's, under the current rules, or the CBE handling of informal conferences, even under that structure, there always has to be an active California bar member at every
There was
informal
discussion of
conference,
dropping
at least
that,
one.
so I'm glad it has to be.
Yeah, and because we have public members as well, but at every informal conference, there should be an attorney there. And when we switch over to staff conducting informal conferences, that's one of the reasons we brought an attorney on board. That's why, David is here. And in fact, we're just in the process of finalizing sort of the internal guidelines with respect to how staff will conduct, these informal conferences.
And hopefully our group will get to see those internal guidelines
If
as
you'd like
part
to
of
see
our.
them, if you'd like to see them, we'll share them with you.
Overseeing how the whole thing works, I think we need to see.
And also, in the upcoming, we have a meeting on June 21st with the CBE in Los Angeles, I believe. And at that meeting, the proposed guidelines for how the Committee of Bar Examiners will perform as an interim administrative review body will be on the agenda for consideration and for approval. So, because there are separate standards, guidelines that we've drafted for that process as well. So that'll be on the
We
agenda.
added a couple of steps.
I'm sorry?
Are we adding a couple of steps that didn't exist before? So
The
this
only
is going to
step-
delay everything?
Yeah, the step that didn't exist before is the Committee of Bar Examiners acting as an interim administrative review body. So, before, as it stands now, presently, we have an informal conference, and then the informal conference recommendation is made by the panelists who attended the informal conference, and that recommendation is presented to the Committee of Bar Examiners that either affirms or denies or makes some other recommendation with respect to the outcome of those informal conferences. And then the applicant, assuming there's an adverse determination, can then appeal directly to the State Bar Court, and there are rules in place for that. Under the new system, there will be that interim step where staff will make a determination, and if the applicant wants to contest that determination, then they go to the Committee of Bar Examiners for interim review.
Just because I don't know, one of these steps, isn't the applicant allowed to appear, or does they have to appear?
So that's the informal conference.
Oh, that's the informal.
So they would meet with the members, currently as it stands, with the members of the committee, and then after the rule changes are approved with the members of staff.
Okay, thank you.
And I think maybe we're asking this also, who's making the determination that there needs to be an informal conference?
Sorry, we'll get to that a little bit in the next step,
Okay.
but it is a staff determination.
There will not be a member of the Committee of Bar Examiners involved in the informal conference panels once this new system starts.
I think that's a discussion that we will have internally. Right now, the internal procedures as they've been drafted, the panel will consist of the program manager, the attorney, and perhaps one of the investigator assigned to the case, but not a Committee of Bar Examiner, not a member of the Committee of Bar Examiners. Now, whether they can come in and maybe observe, that's something that can be discussed, but not participate. There will be, with respect to the guidelines that's developed for the committee's administrative review in those guidelines.
Appeal in effect.
The appeal, interim appeal, those guidelines have been drafted so that in exceptional circumstances, should the Committee of Bar Examiners decide they want another informal conference, the committee can decide that.
And all of the decisions of the informal conferences still go to the Committee of Bar Examiners for
No.
Oh, so
Decisions are made by staff.
they're made by staff, and then where does it go once that decision is made in the informal conference by staff?
It goes to the applicant. I mean, that's the decision
So it's
that's
done.
made. It's done.
So if they decide
Unless the applicant
Unless
contests.
so if the applicant doesn't appeal, then it goes direct, then it's done, they've gotten their moral
Yeah, then
character.
they can
They've
reapply.
gotten it,
If it's an
they-
adverse decision, they can reapply after 3 years.
Right, okay.
Or shorter if
Right.
we
And
decide.
so there's no mechanism for, quote, appealing, I can't think of a better word right now, a positive recommendation. In other words, correct?
No, well, number one, why would, the applicant want to appeal a positive?
No, but the applicant.
I mean, we're certainly not going to contest if
But
it's
the
a positive,
applicant-
we're not
no,
going to
the
contest it
applicant-
either.
But let's say, right now what happens now is that, there are people on the committee who might say, well, this person should not be passed. Okay, but that won't happen now. It'll only come to the committee if the applicant
That's right.
appeals.
That's how it's currently structured.
Okay.
Now, on a positive note, if the staff at the informal conference gives them a pass, that pass will be effective immediately.
Correct.
It does not have to go to the full committee, whereas currently, if the informal conference, we said we believe this person get a pass, it may take 30 days for the full committee to rule on what the informal conference made a decision on. So it'll actually speed the process up for people who pass.
Speed for approval.
By about 30 days. So there will be some speeding up for some people.
No, that's good to know.
Correct? And that's how I understand it.
That's correct. And I mean, in some cases, since the committee meetings right now, I think are held 7 times a year, it could even be longer than 30 days currently when they have the informal conference to when we finally get the approval from the Committee of Bar Examiners. So,
Everybody has to have an informal conference.
no, so we'll get to
Yeah,
that
okay.
right now. Okay. So internally, we have our own policies and procedures. So once a file gets to the investigator level, we kind of have a basic guideline. This is a very simplified version for you. It's not comprehensive. But investigators are able to clear the lower level files. If there's anything that needs further review or depending on the degree of seriousness, it would be referred to the supervisor. And then if the supervisor feels they cannot clear it, then it would be referred to the program manager. And that's when the program manager reviews it. And if staff feels they cannot clear it, then that's when the applicant would be invited to an informal conference currently with the CBE and going forward with staff members. So again, we view the applications in totality, so we also look at their rehabilitation and things of that nature. So this is kind of just to break it down a little bit for you. So generally, investigators can clear the lower level to level 1 or 2, the program supervisors 3 and some 4s, and then the program manager has the ability to clear them unless they feel that more information is needed. So.
Yeah, a question. Oh, I'm full of questions. Academic probation, does that mean for something like cheating or just poor grades?
Not
Discipline is
necessarily
always
for
separate.
grades. No, we're looking for, academic probation is not necessarily misconduct.
Yeah.
So this is sort of misconduct-based evaluation.
It's only for misconduct, isn't it?
Like plagiarism.
Yeah, you're not looking for grades,
No.
because people go on academic probation for poor grades.
Some things we do make note of, but it doesn't have a really big factor. So previously, the application did ask specifically for academic probation. It currently does not. However, if we are informed, we just make note of it. So after the informal conference, as it stands, the Committee of Bar Examiners has several decisions that they may make. So one is a positive determination, as Jim mentioned. Again, that's valid for 3 years. And if the applicant has not yet been admitted to practice law before that is expired, they may submit an extension application. the committee may decide that they don't have enough information at the moment. There may be something specific that they're looking for, or they may ask us to dig a little bit more, and so the application may be re-referred for further information. And we also have the option of abeyance. So you do have the material, I apologize, I don't know what tab it is in there that lists some of the abeyance options. It's not comprehensive, but the most common ones. So for example, someone who may have a history of, let's say, DUIs or some sort of substance abuse program, we may refer them to the Lawyer's Assistance Program for a specific period of time. And then finally, we do have the negative determination. So the standard denial is for 2 years. However, the committee does have the option to shorten that or make it longer. I think the shortest I've seen is 6 months, and typically the longest is about 3 years. And after that time period, the applicant is able to reapply. So once an applicant receives a negative determination, they do have a couple options to appeal currently. Again, with the change in the rules, there would be another interim step. But so as it stands, the applicant is able to appeal to the State Bar Court Hearing Department, and the hearing department may either uphold the denial or determine that the applicant does have the requisite good moral character. And the non-prevailing party may request review by the State Bar Court Review Department, and again, the non-prevailing party may request appeal to the Supreme Court by petition for writ of review. So kind of how David mentioned in those cases, the State Bar Court actually, its own, like, reversed the committee's decision. However, the Supreme Court upheld the committee's decision. So that's all I have, unless there's any other questions.
Question about the informal meetings. So when it moves to staff, I know you said 2 to 4.
Have your mic on, Meredith.
You said 2 to 4 committee members currently sit in on those. Will that still be the plan when it's turned over to staff?
Correct. I believe the panel will be about 2 to 4 people. There may be 1 or 2 other staff members in observance, but the panel will typically be 2 to 4.
Do you anticipate any situations when there would be a tie, if you will? I mean, what would the scenario be there?
Ideally, we try not to schedule anything with only two members. Same thing with the Committee of Bar Examiners right now, so I think we'll move that practice going forward. We have the ability to do 2, but in practice, we always try to have at least 3 people there as part of that panel.
We have had, I don't believe, we certainly have differences of opinion in informal conferences, and I think we've had a few times maybe when there were 2 people, Jim, but there's always a consensus that ends up, being reached typically. So I don't recall when there were 2 and people butted heads, but there's a discussion and usually a consensus is reached.
That's an interesting question, because in the past, even if it was 2 to 1, we would go back to the main committee where there are 16 people, and both sides would express their views, and then the committee at large would have a discussion and could vote on it, and then you've got 16 people voting, and I think we never had a tie with respect to that. This is an interesting question now, when you only have staff doing this. If in fact staff has a tie, what is the process? And that's something I think you ought to look at. Because you aren't going to a bigger body like a court or whatever and saying, we're going to have the whole in-bank decision. It's just going to be the 4 people. So I think that's a good point.
And so sort of as Larry was saying, if the applicant wants to appeal, there's a mechanism, but what if there's a tie or a dissenting opinion among the staff?
So just kind of explain to you, because I'm not hopefully you've never been in an informal conference to know what's going on. So an informal conference, at least in the past, is taking place in San Francisco or in Los Angeles. It's a small conference room. We try not to be overbearing to the applicant. The applicant will come in. The applicant has the right to have an attorney present, although the attorney is not allowed to talk or argue. The attorney is simply allowed to watch. The process is recorded, so that the applicant has a right to recording when it's done. What we as committee members will do ahead of time is we will review the record. We will see all the application, all the criminal files or court files or things from school, the recommendations, everything we've got here, and we'll review that ahead of time. Usually there are 4 to 6, maybe 7 informal conferences in a day. So we have lots of reading to do ahead of time. And then we'll basically talk to the applicant. We'll explain to them that we want to know who they are as a person. We've read who they are, but we don't know them as a person. And then we'll ask questions. Well, we see that you had a drunk driving conviction 3 years ago. Can you tell us about how that happened? Or you were caught shoplifting or something of that nature. So we ask them to explain the situation. And we say, well, what did you learn from it? What have you done since then to show her rehabilitation? And then we'll kind of informally try to get to know them better. And then at the end, allow them to provide more information. At the end of that conference, they will leave. Then in the past, the 3 conference or committee members will talk about it and say, do we think the person was being forthright and honest? Do we think they were trying to hide something? How do we deal with this? And then we will say, we believe this person is entitled to a pass and make that recommendation to the full committee. We'll say, no, this person really doesn't make it. We want to deny him. Or we might say, this person still doesn't quite understand their drinking problem. And you have to tell me how this is going to apply in the future, but I want to tell you what happens now. So we might say, we want to send them to the Lawyer's Assistance Program. We want to have them talk to a specialist and Lawyer's Assistance Program or LAP will come back and say, we've met with this person and we believe they have insight into their drinking problem and are recovering, or they have no insight whatsoever. They have no idea they have a drinking problem and they really need a lot more help. So that's where the abeyance may come in. Or we might say, this person really doesn't quite get ethics yet, so we want them to take 10 hours or 20 hours of ethics MCLE before they can become licensed practice law. Or anger management, we might say we want them to participate in a 12-week or 24-week court-supervised anger management program and pass that program. And if they do, then we would give them a pass. But until they pass that, we don't want to give them a pass. So now the committee, the staff will make those recommendations instead of the committee. And the committee basically is going to be, I don't want to be political here. We're not quite sure what the staff's going to do, but I have a lot of faith in staff.
I think the idea is to keep it generally the same with the abeyance options. So having the same, being able to make a positive determination, if we decide there's more information needed, offering abeyance as Jim described, or the denial, and then which, in the event that the applicant is denied, they're able to appeal to the committee of bar examiners.
So once it gets to the committee, they could change the decision.
It will only get to us if the staff now denies the applicant.
No.
And the appeal.
And the person appeals.
And the person appeals.
Right, so if the staff denies and the person accepts the denial, it won't get to the CBE.
Now, part of
Correct.
what I think our working group can do is say, we think certain things should still get to the committee because we think, for example, if it's a serious felony, we'd like to have the committee look at it. They may not follow our advice, but we can make those recommendations. Or we can say, this is great. And I think later on we're going to say, staff, here are things that we think are important for you to consider in having this informal conference. I think that's the purpose of this working group. Why we're here is to help you get a better understanding of how you're supposed to look at things, and so that the students can get a better idea how to look at things. Isn't that what our purpose of the working committee is? Okay.
Also, Patrick, in response to your question about what the committee can do when they're reviewing these adverse moral character determinations, should there be an appeal, the committee can make whatever decision it wants. It doesn't have to affirm the staff decision to deny or not grant a positive.
They could do their own abeyance rule.
They could do their own abeyance. They could call for an informal conference. They can pass the person. At that point, the committee can make whatever determination they feel is appropriate.
Or, for example, we might say, we want more information. Or sometimes what we've done in the past, we've gone to trial counsel and said, will you look at this case? If we deny, do you think you could win a state bar court? And trial counsel sometimes comes back and says, nope, we can't win in state bar court. And then we have to talk about what that means. Or they'll say, sure, we can win, and that gives us some feelings that we can move ahead in that front.
And also in certain situations, trial counsel, we've been invited to the informal conferences also, and just to weigh in what we think, whether the applicant would be successful or not, and also evaluations of credibility, et cetera, just to give additional input.
But sometime, maybe today's not the right time, I hope we can figure out, where do you guys get expert information to help you with these decisions? You say you don't think somebody recognizes a drinking problem. I'm not going to assume everybody on the committee is an expert in recognizing drinking problems. Do you go to AA or somebody? I mean, how
That's
do you
what the
learn?
LAP is.
That's what the lawyer's
The
assistant.
lawyer's assistance program would make that evaluation.
Okay. Yeah.
We can actually refer it to a psychiatrist to evaluate the person and provide us with an opinion. So there are resources that staff will be able to go to get information.
And it's alcohol, it's all kinds of substance
Yeah.
abuse, it's,
But
I guess it could be any kind of problem, right? It could be a gambling addiction, right?
I think following up though on Patrick's comment, beyond sort of like lab issues, what kind of training does either the CBE get or now the staff will get on being able to evaluate, let's say, the relevance of a criminal record, the nature of a criminal record, the nature of rehabilitation? I mean, some issues are very cut and dry and some are more complicated, and I don't know what's funny, but
I'm sorry, I'm not being funny. Amy's ready to talk because she's got some great stuff to answer your question. I wasn't
I mean,
laughing
I
at you.
think that there's a lot of, and we have a report that's coming out on this. I mean, there's criminological research on desistance that I think is very relevant to this kind of decision making. And I don't know, most admissions officers don't have access to that information, and they're the front end gatekeepers to law school. And I doubt, I don't know whether or not the CBE or the staff has access to that kind of information.
Okay, you want to start?
Oh, yeah. So a couple of things. One is that, and maybe this got mentioned, and I apologize, I had to step out of the room for a second, but the staff that will be sitting in on the informal conferences are not staff that are far removed from the process. These are people who've been working these investigative cases and are actually making the recommendation for it to go to informal conferences. So they already have the mindset and the skill set to critically assess these cases. And as far as another tool that we're going to be developing, and that was part of the recommendations, is a case decisional library. That is creating a library based on decisions that have been made by the CBE on some of these informal care conferences, so that we would have a historical context of like, what have we done in the past with this category of crime or issue. And so we would have something to refer to as well. And the other thing is, in terms of training, one of the items that appears on every single CBE agenda is we have goals for each of our subcommittees. So we have a set of goals for moral character, we have a set of goals for examinations, and within that we always add a training component. I think this year one of our goals is to look at domestic violence and I think the dynamics between victims and offenders. So we bring different items. Last year we had a session training on signs of rehabilitation. So we're constantly trying to do that, and I think now it's a matter of bringing staff on board with some of that.
Yeah, and the report that you're referring to that you all are coming out with, it sounds exactly like the sort of thing that would be useful.
And I might also add, with respect to the decisional law library that was referred to by Amy here, that will be a decisional law sort of compendium that incorporates not just Supreme Court cases, but state bar court cases as well. That will be shared not only with us, but probably shared with the Office of Chief Trial Counsel as well. We intend for that to be very thorough and comprehensive because, it is that decisional law both in state bar court and in the Supreme Court that ultimately gives us the guideposts that we need in making these kinds of decisions. So, I think that's going to be a very important part of what we do and how we end up making these kinds of determinations. And David here is going to, take the lead on that.
Though I think, and I misunderstood what Amy was going to say, we had a program last year on PTSD, which I think was very important. We have one coming up on what is LAP, how does LAP work, and how do you apply it. So truly, that training is critical. If the staff doesn't really understand what the problems are, they can't really do their job correctly. And so the staff's been very good at bringing that training in. I think Amy's right. We need to make sure the staff gets that training just like the committee has in the past. That's critical. So. So I think it's important. And I think that's part of what our committee can do in its recommendations. Say, we believe that staff should have training in these 5 areas or these 7 areas to help them do the job correctly.
To add to that, my school's involved with collaborative courts. The Office of Court Management, is that what it's called now? People that run the courts up in Sacramento, they've got huge grants out in collaborative courts. They've been gathering statistics now for 15 years on rehabilitation. And I would hope that somehow all that information is something you guys use and incorporate. See, we don't know that, so we'd like to hear if you do or don't. It's really an interesting program. Yeah.
We've had collaborative courts present to us in the context of like Veterans Court and
Yeah.
other courts. So, yeah, it is something
And
that we
drug
can.
court
Yeah.
and the people that are coming out of prison, the felon, reoffender. Yeah.
Yeah. So it's something that we could definitely incorporate.
Good.
So one of the advantages of having informal conferences being done by staff as opposed to CBE members is that there can be a level of quality control, frankly, that doesn't necessarily exist now with CBE members. Which I'll be frank, has always been one of my concerns. Okay, the lack of consistency, because you're a volunteer. You can't make me learn to understand things like rehabilitation or whatever. But you can say to staff, you've got to get trained on this stuff before you could start passing judgment on people's ability to whether or not they're going to be admitted to the bar. So I think that's an advantage. I want to go back to another thing though, which it's interesting, and I don't know if there's an answer to this, which is you can appeal. The bar, the CBE will hear appeals of denials. They'll never hear appeals of admittances that might have been not a good idea. In other words,
No review, you mean.
No,
Yeah.
Right, there'll be no review.
There's no oversight over the staff decisions, is what you're saying.
In a way, yeah, so is that a concern? I don't know. Is that a concern?
So
Oh, sorry.
that was of a concern to me. My recommendation was that although a CBE shouldn't participate in the informal conferences, the CBE members should be allowed to at least watch, like we can watch the state bar court decisions, and go back to the committee and say, hey, we think there's a problem here. So I think there needs to be some oversight by the CBE. Whether or not I can get that, I'm not sure. But I think there should be some oversight. But staff's doing 90% of this anyway, so they can pass a lot of people. Sorry.
Oh, sorry. I keep cutting you off. I'm sorry about that, Jim. So a couple of things. One is that this model of decision making, in terms of using staff to make the initial determinations and the CBE as the appeal body, is reflected in every other policy that we make, whether it's a testing accommodation. Testing accommodation is like I think the model that this is based on. So staff makes a recommendation or the initial determination on many of these cases, and any of the ones that have been appealed are the ones that come back, and that's what we're modeling this after. So and so we don't make a list and ask for affirmation from the CBE on those initial determinations. So that would deviate from that model. And it's worked for us. The other thing is that I think Jim's pointed this out. When we're talking about informal conferences, I think the ratio of the number of cases, and Tara and Mark, you would know this best. Are we talking about? Is it 10% of our cases go to informal conferences directly, or is it 5%?
I don't even think it's. I think it's more like 5%. It's a very, very small number of cases. The informal conferences are reserved for the most serious types of cases. It's a very small subset of the thousands of moral character applications we get on a yearly basis. I think last year we may have done maybe 200 informal conferences. In years past, that number fluctuates between maybe 180 to 250 in that range. But when you think that we get how many moral character applications do we get a year? Maybe 8,000-9,000 applications. You're really talking about a very tiny universe of cases that ultimately reach that stage, and then a good portion of those do in fact receive, positive determinations. So I think just to put things in context, that's what we're
Well,
looking
without being too negative, I think the issue is, how do we know the people doing that work are doing it the way we like it? Is somebody overseeing after they do these informal things and signing off and saying, yeah, you did it right? Or they just get to do what they want and off it goes? And maybe, I mean, how do we know there's not bribes involved? I mean, there's just no, we don't know. We're just saying, oh, we train these guys, let them go. You know, that's always a concern. I was in the Navy, I'm always looking
I
for
think
rules.
David is our gatekeeper, and that's really why David was hired, isn't it?
Yes, but also the sessions are recorded. I mean, they become, they potentially are treated as evidence. I mean,
Right, so we have, we have the record, we have the applications, we have all the documentation, it's recorded.
So it's reviewable.
Yeah, and I just want to reiterate what Amy said, which is that, we're dealing with staff who've dealt in this area for a number of years. Ultimately, Amy and I sort of oversee, that, the moral character area, and it's actually run by Tara, who's been here a number of years, and we have investigators who've been doing this work for years. And I think with the decisional law to guide us and with the training to guide us, as Debbie is suggesting, and is absolutely right, I think we have, I think we can have appropriate faith put in the staff to do the job that they were hired to do. So that's not a concern that I've ever had.
Yeah.
So.
And not to speak out of turn, since we don't want to set the agenda for the working group itself, it's for you to set, but I think as staff, we were hoping that as part of the working group, Debbie, that your report would be a topic for discussion, so that way that could help shape some of the rehabilitation that we work into the new statements and guidelines, so.
It's at the designer right now.
But also, there's no place online here where you invite the public to participate.
It's literally at the designer right now, and so I'm hoping it's going to be released by the end of this month.
Okay.
Yeah, but I can share it with you, Mark, and Tara, and you can send it around if it's appropriate.
On a final note, just because I found it interesting, I'm going to share it with you folks. So after you get a positive moral determination and after you pass the bar exam and staff figures everything is needed, actually they prepare a petition to the Supreme Court with lists of names. Sometimes there are a few, sometimes there are many thousand. Mark will sign it usually because he's the head attorney, but David may sign these. And then the Supreme Court gets that and somebody in the Supreme Court signs off on it. So in theory, the Supreme Court is the final court of review, but I don't think they look at it, but that's how the process works.
The motion goes out every Wednesday afternoon. I sign a motion to the Supreme Court certifying that the individuals on that list have been certified for, found eligible by the Office of Admissions.
I'm just raising it as an esoteric question. You know your neighbor is a totally dishonest human being, never been convicted. You don't know he's applying to become a lawyer, so you don't know, where do I complain? This guy shouldn't be a lawyer, because you don't even know the process is happening. That's the public involvement I wonder about. And then he becomes a lawyer, and then they tell you, oh, don't you realize the crooked things he's done? He's been beating his wife for years. He's had incest or whatever's going on. That doesn't always come out automatically. But somebody knows it, how do they become aware that they
Well, the public does send us letters that says you shouldn't admit this person because of this,
but
that.
how do they know the person's even applying? It's just a question.
During the process, we also do send out questionnaires, so it could be to a former employer, it could be to someone they put as a reference. And even though the applicant may list this person as a reference thinking they're going to give me a great determination, we find out a lot of information from those, I think.
Oh, I'm glad to do that.
So both of those are me.
I won't make any letters, I thought, because I put down I was a reference, but I'm glad to know you do some, just on.
Yeah, and I think we send out, what, 7 reference letters? How many?
It depends with each case. We require at least 5 personal references for the determination application. For the extension, it's only 3, but then for the employers, we send out quite a few.
Oh, and that's another point I think, and I'm throwing stuff up and I apologize because there's so much stuff that goes on here. The way the basic process works is the applicant fills out an application, correct me if I'm wrong on this one, and they have to provide with 5 references. If they fill out the application correctly and they get the 5 references, there is a presumption that they are of good moral character. So they've met the initial burden of proof. Then it is up to the committee to rebut that presumption and show evidence that they are not of good moral character. And then if in fact we believe we've rebutted that presumption, then it is their burden again to overcome that rebuttal of the presumption of.
But it's not gonna get to you.
Well,
It's not gonna get to the
but it may
committee.
get to the state bar court. So if this goes to the state bar court, it's a three-step process. First, presume you are a good moral character by having completed the application correctly and getting your 5 recommendations. That meets your initial burden. And then the burden shifts to the committee to prove you're not a good moral character.
Well, it goes to the informal conference.
Right.
And then they say you're a good moral character. It never gets to the committee.
Never gets to us. That's correct.
Are you saying that by virtue of submitting 5 names of references, you are presumed of good character?
Yes.
Or by virtue of receiving 5?
No. I'm sorry.
Just me listing 5 names is a presumption of.
Yeah, no, do you want to weigh in? No, I mean, the mere fact that we receive 5 references that doesn't make that there's not a presumption that you're of good moral character, because there's so much more we're looking at. It's just that good references are not proof of rehabilitation, but they are in fact relevant to rehabilitation, but they are not dispositive in and of themselves.
You're also submitting fingerprints and getting criminal history.
I think what Jim was getting at is in the actual appeals process in state bar court, the initial burden for the applicant, the prima facie showing it's very minimal. They just present some character witnesses, essentially. They're taking kind of at face value, whatnot. And then it's the committee's job to rebut that. So I think that was a little bit more.
But that's the process when you're actually in state bar court and when you're actually defending, these kinds of, when we're actually defending these kinds of cases. The burden is different than when you're an attorney and you're facing disciplinary action. The burden is on the applicant to prove he or she is of good moral character. In a disciplinary action, it's the other way around. We have the burden to prove that the ethical violation occurred. And so once, we're talking about the state bar court process. Jim is right that that initial burden that the applicant has to demonstrate that he or she is of good moral character is a very easy burden to meet, because all it takes is a few assertions that I'm a good person, and the moral character, the reference letters, a few reference letters, and good reference letters, and that's enough to satisfy that initial burden.
Is that rule set by the state bar court?
That rule is set.
Not set.
That rule is set by the Supreme Court.
By the Supreme Court.
Okay, and then the burden shifts to us to prove, okay, they've met their nominal burden, and now it's up to the Office of Chief Trial Counsel to show otherwise, which is a larger burden. We have to show, not the burden shifts, we have to show that the person does not meet the good moral character standard. And then after that phase is done, then we go into the rehabilitation phase. And am I right,
Yeah, once
Michael?
it's in the state bar court, I equate the whole process. It's almost like a tennis match. It's like the applicant comes out first, and he'll serve the proving that he's a good moral character. And as Mark said, and as Tara said, that's a very low burden. They can just tell about all the good things they've done in life. They may present maybe 1 or 2 character witnesses that show how good they are, and then they'll rest their case. And then the burden shifts to the committee, and through the Office of Chief Trial Counsel, that's when we present the evidence of bad moral character, and we bring out everything that we've had through our investigation, and we begin with the report from the committee and all the findings they have, and also the materials we get include usually a CD of the informal conference, and there's a 120-day investigation period even before trial, and we have some very experienced investigators in our office who, in essence, they investigate the life of the applicant, and they turn over every stone. Nothing is left that unknown about this applicant. And if we're proceeding, we feel we have a very strong case, and we will. We have to fly witnesses in from the East Coast. We have to fly in one of their third grade classmates who they called bad names or something like that, will do that. And usually by the time we've presented the bad moral character, then we volley back to the applicant. Now, you prove what's your rehabilitation. And that's when they have to try to put on their case of community service or restitution they've made, you know, to show that and then they'll put on maybe more character witnesses. And of course, we cross-examine and usually we can impeach them. And the one important thing I just heard mentioned was a bit about the character letters that are sent out by the committee. And it is true. Every time, just because a person is used as a reference, that does not guarantee they're going to say good things about the applicant. And especially the employers, that is sometimes that can be a goal for us, but they're usually very truthful. So that's how it goes. So, and then it'll be up to the state bar judge to write a decision at the conclusion of the hearing to determine whether he's made a finding that the applicant has a requisite good moral character for admission to the state bar.
Mark and Tara, you both said that of the 9,000 annual applications for moral character that you work on every year, about, I think you said approximately 200 end up having an informal conference, go to informal conference. Of those, how many then go to your office, Michael? I'm just trying to understand the flow and how it tapers down.
It can vary. In
Okay.
in an average year, we may actually take to trial 3 moral character cases, sometimes a little bit more, sometimes less. It just varies.
And of those 200 that go to an informal conference, I would say the majority are not denied.
Right. They're considered.
Either positive or abeyance.
Right. So, yeah.
And you know, those may be the ones they take to trial, but they're, like, for example, right now, I think percolating in the, with the Office of Chief Trial Counsel, and of course, we don't want to get into names or circumstances or anything like that. I think we might have 10 maybe, something like that. And then oftentimes what happens is that an appeal is filed and then we notify the Office of Chief Trial Counsel, who are our attorneys in State Bar Court. Oftentimes, you know, once they start going through the process, they'll withdraw their appeal because throughout that process, you know, you have mandatory settlement conferences, there are depositions. I mean, it's a formal hearing, and through that process, oftentimes the applicant will realize, you know, either they don't want to fight because they realize it's going to be a significant process, or they realize that they come to some realizations about the indefensibility of their matter. You know, that happens too. So, ultimately,
a lot of those,
go ahead.
It helps when you have a state bar judge, which, as Mark just mentioned, will schedule settlement conferences. Sometimes it's early, even before the response by the committee is due to the application for the moral character hearing, and that's just to give the applicant a reality check. Now, most of those applicants are in pro per; they're not represented by the what we call the regular counsel that appear before the state bar board. Because the regular counsel, if the applicant doesn't have a chance, they usually are candid and will tell them that. And the applicants sometimes view us as being advocates for the committee, and we understand that. So we'll say, well, how would you like to have a settlement conference before one of the state bar judges? And usually the judge, after they've reviewed, will do a settlement conference brief, and the applicant has the opportunity as well. And when they hear it from a state bar judge, that's very convincing. And we've had many applicants that have withdrawn applications after a settlement conference. So.
And that's also not to say that we haven't had times when the state bar court judge will tell the committee and counsel that, you know, this is not your strongest case. You know, so that's happened too as well. And we don't win them all.
What's the time frame? They can reapply after 3 years, or?
The standard denial is 2 years. However, it's the committee's choice right now. The shortest one in recent history has been 6 months, and typically they'll on the longer end it's 3 years, but the standard is 2.
But it's 2 years from the end of the process. So if they appeal, it's 2 years from when the appeal is denied.
It's 2 years actually from the date of denial from the committee.
Oh, I thought it was from when the court
No.
No, so the appeal
So-
process
so
can
you-
happen while they're,
Right.
they're
You could,
while they're
you could theoretically be on appeal and reapply at the same time?
Typically, they don't do that, but what'll happen is that, I don't know, how long do the appeal processes take? Maybe a year or so?
Can be.
So maybe they'll use 1 year of that 2-year denial period for the appeal, and then they'll come back after the next 2 years, so.
Yeah, the bar passage is still good for life, so they might keep coming back for 10 years?
The bar passage? Bar passage?
I don't think it is
That's,
good
it's for
for
5 years.
Yeah, so I mean.
It's only good for 5 years.
That's my point.
So, interesting, several of the informal conferences we have every year are people who were basically denied the first time and are coming back for essentially a pass. And probably half the people who come back say, I'm glad I was denied the first time. I really didn't understand I had a problem. And your denial kind of woke me up. I got my life together. I won't get into specifics, but I've had some people who, you look at them now and they were denied 3 years ago and they are significantly better today. And you say, I don't have any problem passing this person today. They've gotten their life together. So the denial sometimes helps people.
I just wanted to say that it sure would be nice to get numbers. I know that Debbie brought that topic up earlier, and there was some indication that we might be able to get some numbers. But I'd really like to know how many of these situations involve, for instance, embezzlement. And what are the decisions related to embezzlement or murder? I guess theoretically, it's possible for a person to have been convicted of murder, serve their time, become a member of the bar.
I know two that are practicing.
Really? Okay, see, I haven't known that. And it would be interesting to know what are the numbers? What about child molestation? It would be good to know that for purposes of being able to answer questions that are asked of prospective students who are applying to law school. And it would be nice to know it otherwise as a member of this working group.
So let me just throw out that we have to be careful because moral character applications are confidential. And it may be possible, but we may have to give you a really large time span or something so that it's not identifiable who we are talking about as the child molester or, whatever the issues might be that you're trying to drill down on.
Well, but also, I'm sorry, I was just thinking about, we do Corey training. So we're trained by the Department of Justice. And it's my understanding that access to these records and any decision or information related to the outcome of a background check, that only people who have been Corey trained can have access to that. So I don't understand how we'd be able to relay that to the general public, is my concern.
Yeah, definitely with a specific Corey, but I think if we're aggregating it, it may not be an issue, but I'll have to take a look at that as well.
But I don't think at this point, I know that under the old system, I don't know to what extent we could categorize these cases as specifically as you might be suggesting, Michael, by type of crime that was committed. I don't know that I don't even know if we could even access the old system anymore.
And if we can, our old system was pretty
Under the new
fragmented.
system, I think we need to look at see whether or not to what extent we are, we could gather that under the new system, which is only a few months old. So I'm trying to raise expectations, Michael, with respect to the specificity.
But even aggregate data on just even if it couldn't be as specific as crime type, even.
Over 10 years.
But also just like the number of applications that, let's say, involved a criminal record versus another kind of moral character issue versus, and then of those, how many were, deemed positive versus a negative determination. I mean, it's just trying to get some sense of.
If we are able to, it'll most likely take a lot of manual work, just to be quite frank, because the old system, I think, it didn't have a lot of capabilities for reporting. Like, as staff, we didn't even have the ability. We would have to contact IT to have them do it. And so certain things I know they were not able to build reports off of, so I don't know whether or not those things would.
Maybe it's just going forward so that, that provides another oversight mechanism, as well as like is being able to use data is a way to also track some of the decisions. If in a particular year, it all of a sudden you get a big change in how these decisions get made, that might be, wow, did we have a new staff person? Is the staff, being able to, one of the recommendations we might make is that the staff use data in a very proactive way in terms of looking at trends.
Well, we don't get a whole lot of serious felonies, maybe one a year. And we get a lot of unlawful practice of laws, a lot of drinking in law school, because I think drinking and law school go together, but.
I mean, I would
No, I
suggest
won't
though,
go that
Jim,
far.
that there's a lot of interest among people who have more serious felonies in going to law school, but there's a deterrent effect. They believe that they will not get into, we did a survey of formerly incarcerated people, and it was clear that they don't even apply to law school because they're certain that the state bar is not gonna admit them.
Is
So,
it that the state bar won't admit them, or that they won't be admitted to law school?
it's both, but we specifically asked about, they specifically in our survey pointed to the state bar.
I know we do get, as staff, we have someone who's called the person of the day. They answer general questions, and at least one call a day is someone who's saying, I have this in my history, can you kind of let me know if I'm gonna get in? We do say on the website, and we try to tell applicants, there's no misconduct that precludes admission. However, everything's viewed on a case-by-case basis, but we can't give you a determination over the phone. So I don't know if some of those factors are playing a role.
And just to come full circle, this working group, hopefully will solve some of these issues by articulating clear guidelines in terms of what sort of rehabilitation is required in certain circumstances. The identity of an offense, for example, alone, I don't have the institutional memory and knowledge that Tara and Mark do, but I imagine that there's not a one-to-one correlation. There's so many different variables, and so a huge piece of this, I think, is going to come out of the working group's product.
Another thought, let me just throw out, is we mentioned before that the cases that go to trial are public. And so maybe getting, we have a database on that would be helpful with
Cases
regard
that
to
go
the types
Supreme
of,
Court are public,
the Supreme Court.
not the state bar court.
So those we have, yeah.
Yeah, we can't
And
reveal
the most
those.
recent is Glass, so it's not.
Yeah.
And the three that David's presented, while interesting to me, are not super helpful to either an applicant or an admissions officer, because they're somewhat extreme.
That said, the hearing department and review department.
I think what we
No, I know, I
we'll
get
do,
that.
I think this is seems to be a particular request, from the working group, and I think what we can do is go back and see what we can gather and see what's possible.
From a law school perspective, let me put it this way. You have an applicant that comes in today, you realize the cost of law school has tripled in 20 years. Tuition, when I went to Hastings, it's $47,000 a year tuition now.
I went to Berkeley.
It was 500 when I went, I
What's
think.
it now? I paid $300 just for.
And so a student is gonna invest a lot of money in this decision, and they come to you and they say, am I wasting my time? I had a manslaughter conviction because I was pledge chairman in a fraternity where one of the pledges died of alcohol, and as you all know, that was a recent case. He just got approved last week, or 6 months ago. So it's a question, what do I tell them? And so some guidance would be somewhat helpful. We could at least say, no, you're going to have a hell of a time, and you can sign, which I do. You're going to sign a contract right here that tells you I can make you absolutely no guarantees. If you're going to come to law school, you're going to really appreciate the JD degree, but the next step's on your own. But I don't know what to tell them. What should I tell them to do for the next 4 years? I'm learning now. Here's what they're going to look at. Get involved in getting out in the community. Do this. Go to AA. I've got an associate dean who's on the international board of AA, and we've really helped a lot of students. And so it's helpful, but I don't want to say something, I don't want to mislead them. So knowing the information would be so helpful.
And I think that's what we're looking for this committee, is to kind of get you guys to help us put something together to staff and say, here are some things the public should be aware of, to give them guidance.
Yeah.
And law students.
To what extent might we be involved with the issues that relate to the Supreme Court's position that no act of misconduct is disqualifying, and a comparison of that to other states that have certain types of misconduct that are absolutely disqualifying for bar admission purposes?
So.
Not sure that we want to be like those states, though.
Yeah, I was gonna say, so,
That more southern
Michael,
states.
what's the specific question you want?
Hey, this is
Well, I
California,
was
we like
wondering
to be
if that-
different.
That's the type of discussion that we might have comparing our Supreme Court's position on that issue to what is being done in other states.
Well, I suppose it's a discussion that could be had, and again, it's, the working group has a particular point of view that, on that issue or other issues, then, they can be articulated in the end product and presented to the Committee of Bar Examiners. Ultimately, any decision about, how the Supreme Court conducts its business, has to go through the Committee of Bar Examiners, the Board of Trustees, and, ultimately to the Supreme Court. So, if you want to express some sense of how the Supreme Court should conduct its business, I suppose you can express that. I'm not predicting what the success would be, however.
Yeah, I'm not looking for additional tasks beyond what you had planned for this group. I'm just wondering if that was one of them.
Not necessarily. I think that the focus here has been on articulating standards and guidelines for moral character to help the applicants and the public at large, and also to guide staff. I think that's the primary focus.
The interpretation of those guidelines is the issue. You've actually given us some that you didn't even realize you were doing. 10 years after you're off probation, couldn't there just be a guideline? If you had a criminal case, you've got to have 10 free years before the state bar is going to consider you for your morals check. So come back to law school 8 years from now or something. I mean, that's not an impossible guideline. But
It's
and
not
you
one
guys
that
said
I
it.
would support,
It's one
though.
they use. They're looking for 10 years free. Then let's just state it up front.
Yeah, I mean, there's a spectrum. On one end, you have art, and on the other, you have science. And I think this working group hopefully is going to push us towards the science end, so there's less subjectivity involved in the process. But ultimately, human beings being human beings, there's so many variables, it'll be difficult to, I think, make a lot of bright line rules, but who
It's a really
knows?
tough issue.
I'm not sure if Tara is done with her presentation, but I'm curious if we will be talking about our deliverables.
So I actually am done with that, so if we wanted to move on to the next portion, I think Jim, we were kind of leading into it a little bit.
Really?
What about things that, because of changing public, societal values change? The obvious one is marijuana. Okay, 10 years ago, 2 years ago, it was illegal. But you might have somebody who's busted for trafficking or whatever. Kind of now it's like, now the biggest problem is how to get a license from the local city, the zoning permit. I mean, how has the bar responded to that?
I think we've been very sensitive, to that, particularly in this area, there has to be a consideration of evolving societal values and changes. We see those, and we get that guidance from the Supreme Court in some of the cases, particularly regarding civil disobedience, for example, in the protest cases, where back in the 30s and the 40s, if you voice some affiliation with communists, then that was grounds, that was
Well, some of
grounds
these
not
old Supreme
not to
Court
admit you, but
cases.
but eventually, we got to the point where freedom of expression actually does count in this country,
Right.
and marijuana is another one of those societal issues where our values begin to change and begin to evolve, and certainly what we're looking at is violations of law, misconduct, something substantive, like that. But there has to be, built into this, and I think that we do it now, and maybe it just needs to be articulated that there has to be some consideration for evolving societal standards and values. But I do think that is something that we're sensitive to already. And I think I've seen you're sensitive to that too. I've seen that in informal conferences, and I understand your feeling on that.
And some of that gets in inherently through the definition of moral turpitude. The idea that one looks at current societal standards.
But the most important thing you said was it's the public interest. So the fact that somebody has a drunk driving, how does that hurt the public unless it affects their job? does that mean you don't interact with the public, you're not gonna be honest or straight? I mean, so that's what you have to look at, whatever guidelines we come up with, not just because it's bad in itself, but does it affect their ability to relate with the public and be honest with the courts?
Yeah, I mean, ultimately, the test is, as the Supreme Court has articulated, is that, you know, is this person a proper person to warrant a license? And, you know, the decision has to be one that's based on protection of the public. You know, we are in fact a regulatory agency, and that's our bottom line.
You know, there was, you mentioned something, and we talked about this. There's the quote, I think it's from Justice Kennard. The term good moral character embraces much more than the absence of demonstrated wrongful acts. And frankly, on some level, I take issue with that. Okay, because I'm not sure it is the function of the government, okay, to determine who is of good moral character. It's the government's function to determine what are good moral acts and what acts are right and what acts are wrong. But character is an intrinsic thing in a person's heart, in a person's mind, and I'm not sure that's the role of the government to decide that. And so, therefore, the burden is on us to be extremely transparent and in some ways sort of have a light touch in that, because you know, we could really go the other way. And you know, as I remember, we discussed we met at the law school thing in LA, and you talked about how the moral character process in many ways was used as an instrument of racial, religious, and sexual orientation discrimination for many years. And so it's really important that we have exercise restraint. And that's one of the reasons I'm really interested in this whole process. So, whatever that's about.
One other comment before I go on, and correct me if I'm wrong, we don't judge fitness in moral character. So there are times when we've had people in front of us and we say, they're going to be a terrible lawyer. They just don't understand law at all. They really need a mentor, whatever else. But that's not our job. So we don't judge fitness. It is simply whether or not they fall within the category. And again, I don't like to say to anybody, you're not a good moral character. I don't feel comfortable with it, but I do it occasionally. So, do you want me to take over from here? So, the goal of this committee, and I think this is what tab 9 is about, is to come up with some court presentation guidelines that you folks, feel are important for staff and the Committee of Bar Examiners to work with to essentially do their job. What I did is I started back to go to tab 8, and I started with what Arizona did, and how they kind of laid out a number of situations and said, these are things that are of concern to us in Arizona. And I think we have something like this, although I like what Arizona did to start with, although I like what a lot of states did. So we have something that staff can see and the public can see that says, here are the things that are going to be essentially cause you to be pulled out of the automatic pass pile and be looked at a second time. And so if somebody falls into this list, they can say, oh, I do fall on the list, so I know I'm going to have some more issues. And again, we make up the list. We don't necessarily take Arizona's list. And then to say, but we have things that need to be considered. You know, how old were you? What was your situation at the time? You know, we have applicants who grew up in gang-type environments and committed crimes related to that area, and then got out of it, you know, pulled their life together, went to law school, and are just outstanding people. And so the fact they committed the crime maybe 6 years ago, but got their act together and went to law school and now are doing quite well, I wouldn't want to have a 10-year ban because they've done great things. Other people just have never changed, and they're the same people who they were 10 years ago. So, but again, having some kind of saying, here are things that we take into consideration, we look at what you've done, and then how the State Bar investigates things and what looks for rehabilitation. If in fact you committed something that was offensive to the public, what have you done to overcome that? Have you participated in, are you now a AA sponsor for half a dozen people? Are you out there talking to other students? Talking to the people about how to not do what you do, and those are the rehabilitation things that we can kind of put on the list. Back to your earlier question about what do you call it? Sorry, I lost my thought here. Candor. So one of the things we've looked at in the past and we should talk about is, if in fact you were involved in stalking, and you told your law school that right up front, not third year when you're applying for the bar, but in the door, that is a positive point for you, because then you dealt with it early. If every step of the way you said, hey, I screwed up here and I acknowledge it, then you've got essentially positive points for candor. Whereas if you're hiding the things and not telling us until we've caught you, then that really makes it a lot harder to believe the candor issue. So those are all things that I think we can talk about. How we do this and how we present this, again, I'm not quite sure yet. You guys are the academics. I'm kind of looking for a line of guidance from you. And I have no feelings where this committee should go or what it should do on, what its product should be. I just would like to help facilitate coming up with a product that, again, helps the applicants and the students. So, having said that, I'm not quite sure where we go from here. So I'd like some input from you folks about what would you like to see the committee do, and how would you like us to get there? Is that fair?
Well, I think I'd like to see more information. I don't know how to gather, but for instance, the State Bar Court, don't they keep surveys and studies that they could tell us in the first 5 years of practice, what is the biggest issue that leads to disbarment or charges? And isn't that something we should then look at very carefully? Is it theft of trust accounts? Is it alcohol? Is it what? They cheated a client somehow, or as a judge ordered them, filed a charge, they lied in court? And then that's what we want to look for. But I don't know how to gather those statistics. I can give you my history and the experiences I've had with it, but somebody must be gathering this information somewhere. And like the collaborative courts, if they're putting statistics together, I know that Judge Flaviano's in our county. He just testified in front of the U.S. Senate. He's very much involved in this collateral court movement. And there's huge amounts of statistics that are backing up the rehabilitation and how it works. We've cut recidivism in half using the courts and using rehabilitation. But I don't know exactly how to frame that. Can we request this kind of information and bring it to the committee? We can talk about it. And then maybe we can come up with some guidelines. What does rehabilitation mean? I mean, I'm pretty vague about it.
It's possible, maybe, Mike, I don't know if you might have input on this, that some of that information could come from the Office of Chief Trial Counsel. I mean, with the caveat.
Yeah, without getting into the confidential stuff.
Right, of course.
But maybe something general.
But they're the ones who know what people get disciplined for and how often.
Well, I know we present an annual discipline report, but I don't know if that report contains a breakdown of what the particular reasons are. But it'll, I believe it'll contain a breakdown of levels of discipline, how many disbarments, how many suspensions, etc.
But that's not dedicated to moral character.
No, not at all.
That's the wide range of
Exactly.
ethics and disciplinary actions that have no relevance to what we're doing here. And I guess my question is, with respect to the data that you're looking for, Patrick, is, maybe more specific, what is it that you're looking for, and then how will it sort of, maybe better articulation of how that data might help what we're doing
I can very
here.
easily say, I once had a student that had 2 embezzlement cases of a huge amount of money, did the second embezzlement while I was on parole for the first. I knew he was never going to get through. I would hope he was never going to get through the check. But he knew that, I knew that, and we signed a contract, and I told him that he passed the bar and has his JD, works as a law clerk, and you guys turned him down. Because that makes a lot of sense. Because embezzlement, you've got to be in trust with clients' funds. But I'm not sure if just because you had a slight alcohol problem, does that mean you're going to mess up your client's legal work? I don't know.
Yeah.
It might not.
You know,
Patrick, our report that we're
Yeah.
going to be releasing includes there's only been one study done.
Yeah.
It was in Connecticut, looking at like the approximate relationship between moral character
Yeah.
issues and then future misconduct
I'd
as
love
a
to see
lawyer.
that, yeah.
I can send you that study, but
Oh,
it basically
fantastic.
shows that there's not a close relationship.
Well, that's interesting to know too.
Yeah, but I can send you the study. And we have a summary of it in the report.
Well, and the issue of spousal abuse that you mentioned at one point is a really big issue these days. And you know, I mean, you can't own a gun anymore. You can't. I mean, a lot of things happen. You can't go to games at schools, but you can become a lawyer. I mean, I don't know. What's the relationship between the spousal abuser, male or female, and their ability to practice law? Maybe there is none. Maybe it's just that they have a bad relationship. And what we're looking at, public protection, they're only bad with their mates. You know what I'm saying? It's so careful. We can't just judge people. We don't know how it comes about.
Well, that's the challenge of,
Yeah.
you know.
And so if I could get statistics, I think it would help us with that.
The vast majority of the moral character cases that that I saw sitting on the informal conferences, I remember the first thing after a couple of the informal conferences that I sat in on, the first thing I said to myself was, you know, the abolitionists back in the early part of the 20th century, from a public policy perspective, they were wrong, okay? Prohibition was a bad idea, but I get it, because alcohol is at the root of a lot of bad behavior in this society. But so the majority of the cases, the felony convictions were related to alcohol. They were DUIs or public, you know, drunkenness or assault because the guy got in a bar fight or spousal abuse because they got drunk or whatever. So, you know, a lot of it comes back to that. How does that relate to the whole, you know, gestalt of moral character?
You know, I think that we can find with respect to the drinking area, which is, you know, I think when we get into attorney ethics and discipline, I think you'll find that a good proportion of the disciplinary cases that you know, end up in ethical cases, end up in disciplinary actions and sanctions, are rooted in substance abuse.
And do we keep them on probation like some states do? Here's your license, but you're gonna be reviewed in a year. You gotta come back and we gotta see what you did. I mean, that's another
What we do
possibility.
in moral character is, you know, we refer them to the legal assistance program typically in order to get them evaluated or put them on a path of rehabilitation.
And they don't get approval until they've
And
completed.
then, you know, oftentimes what happens once we go through what happens in LAP is LAP will do their initial evaluation and they'll come to a couple of conclusions. One, they'll admit them into the program because they'll say, yes, this individual has an issue that needs to be addressed, a dependency issue. Or they may say, no, this person does not have any dependency issue and they're not being admitted. And then, or they say, you know, this person has been in the program for a certain period of time and they have now significant insight into their conduct and into their issue. You know, it is, you know, we see it as a sickness.
Also,
So
there's a lot of
oftentimes when we get those sort of reviews,
Yeah.
you know, then we can use that as the basis to making a determination as to whether or not, if this person gets a significant insight letter from the LAP, typically we'll say, well, good for you, you get it, you know, you've been evaluated, you're in. You know, notwithstanding prior substance abuse issues.
For instance, if I know somebody who, when they're 25 years old, they lied on a job application to get the job, and when they're 30, they lied on a government grant to get a scholarship for their children. I don't think that's the type of person who should be an attorney, but I just my antidote. There must be studies. Psychology must do study on these things that will tell you that people do that habitually, especially if it's over 5 years, or they've done it 3 times over 10, they're going to do it again. But that's not based on a study.
Well, you know, but
I'd
we
like
have-
to see
we
as
have-
many of those as we can find.
But we have Supreme Court decisions that discuss particular acts of misconduct, you know, maybe embezzlement is one of them, maybe murder is
Yeah.
another,
Well, I
maybe
just
money
wanna look
laundering.
at it.
And the Supreme Court, you know, has, you know, I'm sure that there are cases, and you may see them in your narrative, the Supreme Court cases, you know, here's why embezzlement, and this is important, is an important discussion when it comes to determining whether or not a person should be admitted. And, you know, embezzlement raises an awful lot of issues.
There's lots of studies about
And we
that.
have a number of cases, I think, to discuss drunk driving.
Yeah, I was
and
gonna say-
how that has a nexus to the practice of law. We can
Going-
pull those kind of cases and discuss those with you if you'd like.
Going back to a point, I believe, I don't know if Larry, you made the point, or Patrick,
Yeah.
about the way alcohol is viewed and the involvement, and also the change of societal norms. 20 years ago, or maybe even longer than that, almost 30 years ago, alcohol was not viewed, a DUI was not
It was
viewed.
.20 when I started practicing.
Yeah.
It went to .15.
It
It
wasn't
went
viewed with
.12.
the disdain that it has today.
Yeah.
And in terms of standard state bar disciplinary cases, believe me, use of alcohol, and the consequences from use of alcohol, i.e. going into domestic violence cases, or if we have severe accidents involving anything involving alcohol, is looked upon more severely, even by the state bar court level as well. So there is a change by the courts in their view towards certain aspects of society, and in that sense, I think the court is keeping up with how it's viewed, and that's an issue our office we struggle with. You brought up the example of marijuana use nowadays. If somebody had possession of marijuana, 30 years ago, that was a big deal. It was like, oh, this person is terrible. And now, we've legalized, use in your own home. So it's not viewed in the same manner as it used to previously be. And the courts are, I think, evolving in terms of their view of that issue as well. But use of alcohol and domestic violence are certainly two areas we see in terms of the criminal convictions of attorneys. And domestic violence was another issue that wasn't viewed. It was kind of swept under the rug if you go back 20 or 30 years, but now that's a hot button issue, and we really do look at it much more seriously. Unfortunately, the case law that we have, the precedent, is based on 20 or 30 years ago, but we've had a few of our review department cases that have addressed the issue and are imposing harsher discipline for domestic violence and serious misuse of alcohol involving manslaughter or any type of anything beyond the standard DUI.
It's 2 o'clock, so we're going to wrap up pretty quick. I want to make one last comment on the alcohol. In our informal conferences, we do pay attention to what the blood alcohol is. If you've got somebody with a 3.0 or 0.3, whatever, 3.0, that's significant drinking.
That's near death.
Yeah, and there are people who've gotten a couple of these, and you kind of say, this person doesn't quite understand drinking if they still drinking like that. Where you got people who have different ones. So when we talk about what we do with that, the blood alcohol might be one factor to consider. So Ezra wants us to all talk to him about next available dates, and we can do that once we close the meeting, so I don't think we have to do that in public. Just next available date. You've given us the dates, and people can say their availability. So my suggestion would be that you kind of look at what we've done today. If you feel like you've got questions, send them to Mark or Ezra or Tara. She'll make sure your questions get answered, hopefully, and then we can kind of talk next meeting about where we go from here and how we try to
I
help
think it's been a
staff.
really good committee. I really think we've learned something, and I really appreciate the work you guys did. It's very helpful.
Thank you. Yeah, we're looking forward to working with all of you and moving forward, and in the end, creating a product I think that we can all be proud of, and that will sort of help our stakeholders and everybody else who needs this kind of guidance.
Is there a time frame for the working group? Like, is it just as long as it takes to get the work done? Is it a working group that meets for a year? Like, maybe that's an inappropriate question. I just don't.
No, not at all.
I didn't
In
understand
fact, that's, I
the
think,
commitment.
it's probably a little too early in the game to understand the lifespan yet. However, one issue that you might want to discuss or raise is, how often do you want to meet? Do you want to meet once a month? Do you want to meet every day? Do you want to meet every 6 months? I get that, but I'm being facetious, but that is something that you should talk about. But I think maybe, you can have more informed discussion about that once you have sort of put together your direction and structure the direction you want to go. Maybe that's a discussion, after you get a better sense of direction. So that would be my suggestion. But of course, Jim, you're the boss of, you're the boss of me.
I'm just helping to lead. Okay, Ezra, you have something you want to say?
If you'd like to send me via email your dates of availability and also the topics that you'd like to see discussed in more detail. And
Let's do them separate. Let's get those dates. Let's get a date set pretty quick.
Okay. Yeah. And so it's July 2nd, July 25th, or July 26th in LA. And if Debbie could send me the report, I could distribute it to everyone on the panel so you can have time to review it before the next stage.
As soon as it's.
And I'd like to say anything any of you guys get about all this, send it to us. The more you educate us, the better we'll be able to assist. Because we don't know, I'm learning a lot about the process, because I just never got involved with it.
So, what else do I do to officially close? Just say the meeting closed for today, and next meeting will be at date scheduled. Ezra will let us know what it is. Thank you all for coming today.
Thank you.
Thank you, everyone.
Can you share is it legal to share the roster of the committee members? So like, if I wanted to send something to Patrick, let's say, related to what we discussed today, can you do that, or is that not okay?
You shouldn't be sending your co-members things. There's no problem with you having everybody's names and addresses, but you shouldn't be sending out emails to each other just because it is potentially begins a discussion of things that should be held in open.
Well, just like her reports.
What you can also do is.
We can do that from the state bar to all of you,
Yeah.
and he'll share it with everybody.
Okay, no problem.
Thank you.
Sorry, I don't know the rules.
And